Good morning, everybody. Welcome to Home Coach. Hopefully, you guys have had your orientation. Can you hear me? Can you just hear me? Just let me. Awesome, guys. All right, so I'm coming to you from North Central Command here in North Raleigh. From you guys, so we're nice to see all you guys from. We got folks, I think, from the coast to the mountains today. So it's going to be awesome to see you guys. So one more thing, can you see my screen? Can you see my share screen on that, guys? Thumbs up on that. Okay, awesome, 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 good. So here we are in GENUP 3 days before the last day. So get ready to see what your 40, you all should have gotten, I guess, your notice about getting your $45 into the real estate commission before the end of June. So let me show you what your $45 buys. Okay, you ready? Just listen up now. Listen to your screen. Woo! Y'all excited about that? That's what your $45 bought you, was that intro into the GenUp course. So thank you, North Carolina Real Estate Commission. So let's make sure we're all on the right track here. Thanks, Bob Winstead. Thanks for the thumbs up on that. I'll pass that on to the commission. So everyone in this is the GenUp. So if you're a BIC or BIC eligible, this is the wrong class for you. And as far as I know, we have one spot left in tomorrow's class. So if there's more than one on this class, you better hurry up and race to get in touch with Colleen or our front desk. So you won't get credit for this class if you are a BIC or BIC eligible. All right. COVID extensions, guys. Some of you might have gotten those or have been aware of those. I know we've come through some very tough times. I lost a mother and a sister last year, and so I get it. However, those extensions ended on April 11th. So if you think one course is going to apply or not, we were getting questions of this a lot in the last couple of weeks because folks thought they were taking a class and getting credit for this season when actually it was going to last season because they didn't do it last year. So any of those questions, you're going to have to rely to the real estate commission. You probably need to do it fast too if you have them, because obviously we only got 3 days left. So this let me see, what do we got here? This okay, well, you got this thing done. You're going to hopefully get this done today, and if you need an elective, make sure you get that elective done by June 10th, 11:59 p.m. on June 10th. And why do I say that is because many folks have been doing online courses. I mean, we've probably processed a couple thousand of those in the last 4 months, and they shut off at 11:59 p.m. So you won't have access to it. It's all done. The companies that we contract with, those are called by the commission to do that. So, all right, done with that. We've already talked about paying your $45 to the commission. Make sure you do that by the end of June 30th. You can do that online. We got a bunch of folks. You met Colleen. We got a bunch of folks offline who are here to help you guys out on here. So the chat feature is going to be one of those features that is good communication. And just explain, I'm going to be going through the course. I don't reference the book much. I'm going through the book, but I'm not going to reference it a lot. Most of it's going to be the screen and actual conversation. Okay, that's how I teach. That's how we're going to go on here. You should have access to the PDF, but if you have multiple screens or you only have one screen and you're trying to figure out, well, what do I need to have up most? I would say it would be the screen share and the chat. Now, in the chat feature, I'm going to ask questions and stuff like this, and you guys are going to respond in the chat feature. One of the greatest tools we have here with the Zoom classes is you guys are a lot of smart folks that are on here. So we have a full house, 80 some people, whatever it is. And so you guys help each other out on the chats. I'm going to go through the presentation. I've got staff that's going to find questions because I'm not going to be able to answer questions on the chat. We have people offline who will help answer questions and throw links and stuff like that up for you guys. But during the breaks is when I get messages from my staff is, hey, you need to, address Chris Kerrigan's question or Cindy DeMarion's question. Do all that. Okay. And so that's what I'll do when I come back from break. All right. So I just want to make sure you knew that on there as well. This is just a little bit about our instructors. Everyone's a broker in charge. Everyone has to be a producing instructor. All of our instructors have to be producing agents. So so they know the stuff that's going out there. But let's see, what else we got up here? I've got speakers all around me, or that's what I'm looking. I'm not originally from around here, but I see a lot of you guys returning back, or former or current home coach students on that. All you new folks, welcome. We really appreciate your business on it. You guys have made us a very successful company, and we really want you to appreciate your business. And after this course, you'll get a survey. Please fill out the survey on it. That's how we improve and grow and get better for you guys. Okay, this is really important. You see on there, it's about the 24 minutes. Colleen, I'm sure, has talked to you guys about the not missing time. I'm saying this because you really don't have much recourse because of the time frame we're in, right? It's June 7th. You got to have to June 10th. I'm going to just give you some examples. Like we've had folks who have fallen asleep on the call. Now, not because of me, but they've fallen asleep, and like we couldn't even wake them. I mean, people were like actually on the chat going, call 911, right? And literally drools coming down their mouth, they're snoring on the thing, and it ended up they had worked the third shift in a hospital. But y'all, this is recorded. They don't get credit. We can't give them credit. And that sucks because you can't, there's very little, if any, other courses out there that you're gonna be able to take on this. That includes the driving time too. If you're gonna hop in your car, it's all getting counted 24 minutes. Listen, we actually had a student write us and say another student wasn't the one in the seat. Do you know what I'm saying? Where they had a name and they registered as Jane Doe, and there was another student, and this actually went to the Real Estate Commission. We had to send the video and the pictures of this to the Real Estate Commission, and they set up an investigation because they had another person sitting in for them on this. So it's all kinds of crazy stuff. We don't have any control over that stuff, guys. We're governed by the rules of the commission. So just hang in there. It's 4 hours. Do the best. It's gonna be fun. We'll get down. We'll get through it. Maybe I'll be able to get you out of here a little bit early. I'm going to give you a break at 10 minutes to every hour. I might be a little bit early, a little bit later, but it's all going to be there. You'll get to have that time on it. That's where you go. That's where you go pee, take the dog out, get a break. But do me a favor, all right? Rebecca Rice, promise me this. Rebecca, promise me you're not going to take the phone into the bathroom with you, okay? Don't do that. Don't do it. Because we've had people, y'all, that's right, Karen, we've had people like literally in the bathroom going, well, it's being recorded, y'all. Like, and I just want to let you know, we do take fun and watch these things back over again, okay? So don't take it to the bathroom. Don't go to the fridge. Don't go, you'll be able to shut off your screen or walk away from your screen. Don't leave the Zoom class. You can go ahead and take the video off. Okay. Fair enough on that. And along those lines, if we lose contact, okay. So if I lose it, right now we don't have any storms that are in the area on here. And this might happen to you if you do have storms. I know there's a 50% chance of this. I mean, I'm in an office complex, and Zoom has issues during the week and the days when schools are in session. Whether they're in now or not. But if I get cut off, if I freeze or anything like this, don't freak out. We've got Colleen will jump on. She's also a licensed instructor. I'll just hop back on. If you lose connection, you're going to do the same thing. Okay. Just hop back into the waiting room, say, hey, I lost connection, get back in, and we'll carry forward. Okay. Fair enough. Good. Okay. I've already kind of talked about questions. If you have questions, look, we have a sold out class. If you have a question, sometimes, raising your hand, you'll get my attention. But really what happens is if you go, hey, Steve, right? So if Kurt Rogerson has a question, he goes, hey, Steve, he comes to the middle of my screen. Okay. So he'll come right to the middle. So I'll be able to address him and see him on that. Okay. You can raise your hand with the little icons and stuff. That's probably the quickest way. And as long as, and we've been doing this for over a year now, is if you do that little shout out, I'll call on you. We'll go through. I'll answer the questions and stuff like that. It hasn't been a problem in a year doing it that way. So, let's see. You got the tech line. If you have anything, just text that. Facebook, this is just a thing showing that we put up articles for you guys on there for that. It's not like a recruitment thing. It's just articles for you guys. Okay, because it's the 7th. This is important too, because right now our office is completely centered on getting all the recordings in. Okay, you will most likely not get your email certificate until after the 10th. That doesn't matter for you. Don't worry about it. If you stay on this class and you finish this, you're going to get credit. Okay. Now, the certificate, like I said, might not come till like the end of the week. It will not show up on your personal portal by June 10th. Okay. The way this works is we're going to transmit to the Real Estate Commission, just like all the other schools are doing and everybody else is finishing up their schools. Okay. The classes. We're going to transmit. The Real Estate Commission is then, they scrub it. They make sure everyone's getting it for the right year and whatever they do. And then it shows up on your personal portal. Okay. It might not show up for 30 days. Okay. That's their line. It might not be for 30 days. Now, it hasn't been that way. Most of the time it's been in less than a week recently on that. But if it takes, here's the thing. We're not responding to any phone calls this entire week. Okay. It's all by email and we're only doing it for 1 hour because we have classes going on throughout the week here, not just CE classes. If you don't see it, and it's going to be after June 10th, if you don't see it by say June 20th, you need to email me. This is the email address. Okay. I am the only one in the company that can help you get credit for the class. Okay. Now don't freak out. Literally, if you complete the class and you were here, you're going to get credit. It doesn't matter that it's not showing on your personal portal on June 10th. Is everyone good with that? Okay. Because remember, we've got people who are going to be literally will finish their classes at 11:59 on June 10th. Okay. And we'll get those notifications on June 11th that they finished it. And then we go and we submit and we tell them, okay, they finished it on June 10th. Okay. So any questions on this? Anyone want to shout out questions? Whatever. Okay, good. All right, folks off camera. All right, here we go. One of the things that the commission liked last year is these little vignettes. So we've got these little storyline things that we'll play for you at the beginning of each section of the course. And then we'll ask some questions right after that. For you guys, we have five sections. The first two are going to dominate the conversation today. Okay. The very first one is going to be fair housing. We're going to talk about fair housing and NAR. For those of you that are realtors out there, NAR has been talking about fair housing since last year. They implemented some changes to the code of ethics and stuff like this, fair housing. So you've heard about that. There's been some recent development as of March of this year that's national that we're going to actually, I'm going to incorporate into the lesson as well. But that's going to take us past the first break in towards the second break, if not through the second break. And then the second major one is going to be contracts. So that's going to take, those two are going to take up the majority of it. Then we wrap up with cybersecurity, law, rule updates, licensing, education stuff. Okay. All right. So that's where we go. All right. So get ready to listen. Here we go.
Betty hires Ray, a broker, to assist her with locating a tenant for her basement apartment. Betty informs Ray that the tenant is not allowed to have a pet. Ray places an advertisement on social media and indicates that pets are not allowed for this rental. Ray receives an application from an individual with a service animal and reviews it with Betty. Even though the prospective tenant meets all the qualification requirements, Betty tells Ray she will not rent the apartment to the tenant because of the animal. Ray informs Betty that she's in violation of the Fair Housing Act and state fair housing laws.
All right, so you got the scenario. You've got it where you've got the owner of the property doesn't want pets. We got someone who's got a pet, a service animal, and she says, "Forget it. I don't want it anyway." And then the agent, the broker, the property manager says, "Hey, you're in violation of fair housing." So the question is the agent correct? And go ahead on this is your first time in your chat. Go ahead and put in yes or no. All right, so we got a bunch of yeses out there. Not considered pet. Yes, awesome. Perfect, guys. Good. Okay, so so the answer is yes. We got yes. Perfect, guys. Thank you for all that. So nobody's going with a no on that, and so that is I don't think there was anyone with a no on it. So we've got excellent. Let's look at the second scenario.
John owns a residential house and decides to use it as a rental property. In his advertisement, John notes that no pets will be allowed in the property. He receives several applications and evaluates each based on employment, creditworthiness, and criminal history. He selects a tenant and notifies the individual that the application was approved. 1 week after signing the lease agreement, the new tenant emails John and asks for an accommodation for his assistance animal, a pig. John denies the request, stating that, number one, the pig is not domesticated and may damage the property, and number two, the tenant did not request the accommodation prior to signing the lease. Can John legally deny the accommodation request because it was submitted after the application?
All right, so we got the scenario, right? It says no pets. Then we got someone who comes in, says, I don't have a pet. 1 week later, they say, I need a pet, and I need it to be a pig. It's an assistant animal. And then he says, he denies that, says you can't have it. Question is on it, can John legally deny that accommodation? Shallon, Lenfesti, Lauren, look at all these folks on here. Welcome back. All right. Hey, Rebecca Rice, you said yes. Sorry, you just happen to be sitting in the middle of my screen, Rebecca. So tell me why you said yes. All right. I don't want you sweating it out. We'll come back to figure it out because we'll come back to another question.
Sorry.
You got it.
I answered in the chat.
Oh, no. Yeah, I wanted you to speak. Go ahead. So tell me what you said. You said because
it's not domesticated, but also because it was not with the application.
Okay. All right. So let me ask you this. You just stick with me for a sec. Let me ask you what first is what's a service animal? Do you know what a service animal is? What's the definition of a service animal?
Yeah, it's not a pet. I guess I don't know the proper definition of that, but I don't think it's considered a pet.
Okay, so in the law, it's not. I mean, obviously, it's going to be it's an animal, though, right?
Mm-hmm.
Okay, so what kind of an animal can be a service animal?
As far as I know, just a dog.
Absolutely correct, Rebecca. Hey, everyone, give Rebecca. She's the first one on the block. Give her a hand. Good job, Rebecca. So the first thing we're going to define is what a service animal is. That was from the very first one, the very first vignette. Service animal is only a dog. It used to be also a miniature pony. Okay. So if you remember, so I guess miniature ponies, you can't get in New York City in a cab with a miniature pony these days. Stuffing those things into a cab ain't going to work. So they took that off. Okay. Took it off and just said it's going to be a dog. And they only did that about a year and a half ago. So it's just a dog. Now, this is important. Okay. So when we're talking about service animals, they fall under actually the Americans with Disabilities Act, ADA. Okay. Now, like in real estate, we have multiple terms for meanings for words. Like, let's just talk about closing, right? When you say closing, we typically mean in the industry, closing is the day we actually go in and sign the paperwork and hopefully get our check. Closing is actually, by law, is when they record. Okay, so I'm just kind of giving you that definition. Now, when we're going to talk about pets and animals, I'm going to give you some words that have multiple definitions in it. Service animal is going to apply mostly to commercial properties with a little bleed over into housing. Okay. The word commercial, okay, in the law, in real estate, commercial is anything more than a 4-unit property, right? So residential is single family, duplex, tri, quads. Okay. Everything else is considered commercial. Commercial, though, also is apartment complexes. It's also property management. Okay. So there's housing that's involved in the real estate that the real estate community says is called commercial, but it's actually housing when it comes to law, right? Okay. Hopefully we get that. A service animal is just a dog. It's a trained animal, right? It has papers that's been trained. Is the ones that's supposed to wear the yellow vest kind of a thing. Says it's a service animal on it. Now, I know one of the phrases, if you've been with me for a while, I say it's never a problem until it's a problem, and people run red lights all the time. I know you're going to say, Steve, you can buy that yellow vest off of eBay. I get it. But let's just go along with me here as far as the law goes and stuff. And so service animals specific, a dog, trained, and primarily goes towards commercial. So what I mean by that, let's talk about, let's say your Harris Teeter. Okay, well, your favorite grocery store. Okay, we happen to shop at Harris Teeter. I don't care whether it's Aldi's or Lidl or Whole Foods. If someone walks in, right, where's a service animal typically? Let's just say, I'll give you an example of a blind person, right? Seeing eye dog kind of a thing you're familiar with. So that person comes into Harris Teeter. Harris Teeter can ask them, is this a service animal? Yes, it's a service animal. Okay. It's got his vest on, whatever. It's a service animal. Harris Teeter has got to let that person in. Like Rebecca said, the dog is not considered an animal in the eyes of the law. It's considered part of that person. Okay. So when that person walks in with that dog, it's no different than their right arm. Okay. It's part of them. So they walk in and they go and do their shopping. Okay. That's a service animal. Now we go down to an assisted animal on here. And this is a different definition. Okay. There's a different definition. Karen Jones, what do you think an assisted animal is?
Perhaps an animal that would help crossing streets or fetching items for someone who's disabled.
Okay. So, well, what do you think the difference is because there are different definitions. What do you think the difference is between an assisted animal and a service animal?
I'm not sure.
That's cool. Hey, thanks. Jack Ferder, what do you think?
Unless it's specifically assisting disabled people for one type of action, I'm not really positive on the difference between a service and assistant animal.
Okay, fair enough. Is there anyone? No, that's great. Let me just ask. I'll just ask one more person. Sonia Griffin, what do you think?
Would the difference be that the assistance animal assists the person, but they are not legally recognized in accordance to the fair housing, whereas the service animal is?
Oh, okay. So you're on. Great, Sonia. So stick with me on it. Not in fair housing, but according to the ADA. So you're right. It's not an assisted animal is not recognized under ADA. Okay.
Okay.
But it is recognized under fair housing. Now, this is an important thing because Sonia, any animal domesticated can be considered an assisted animal. Okay.
Mhm.
So that dog, cats, birds, snakes, rabbits,
Yes.
anything domesticated, right? That you could have, that people normally would have, right? Not your crocodiles, not your giraffes. Okay. Those are assisted animals. That by definition. Okay. Does that make sense?
Yes.
Okay, perfect. Now, thanks, Sonia. You can go ahead and mute. So everyone, so now we know, okay, there's a difference, right? So you got one that's trained, and it falls primarily under ADA. Then you have the assistant animal that's over here that's not necessarily trained. They're just a domesticated animal. So let's go back to this this person over here. This last example is they came in afterwards. Now let me back up. When it comes to fair housing, that assisted animal is also looked at as part of the person. Okay, just like ADA, in fair housing, that assisted animal is just like their right arm. Okay, however, it's much broader. So now we can have cats and rabbits and snakes and stuff like that as part of it. So Chris Kerrigan, I don't know what you answered, Chris Kerrigan, but in the last example where they came in with a dog after the application and said it's an assisted animal, what was your answer, or what do you think it is now if it changed that person can do? Can the owner still say no go, you can't bring that dog in, or yes, you can bring that dog in? What'd you say, Chris Kerrigan?
I had said yes.
And what you said yes, that they can kick him out, right? Or kick the
Right.
dog out. And why do you think that, Chris?
Well, I was thinking in that case, it wasn't a service animal.
Right. It was an
And so
assisted.
for that reason, they could kick him out. And plus also, isn't there something they could kick him out, not necessarily based on the status of the animal, but because it was causing damages or would cause damage?
Because it's a pig, right? Is that what you said? Stay with me, Chris. Stay with me. Because it was a pig?
Well, yeah, would make it not a service animal.
Correct. Okay. So the pig does qualify as a domesticated animal. Potbelly pigs, for instance, are known and recognized as a domesticated animal. Does that change your opinion of the decision?
Not as to whether it's a service animal, but I guess if they're recognizing assistance animals, it could.
Okay. All right. So thanks, Chris. All right. So let's get to something as far as it being after. Does anyone have a problem with it being after the fact? Trinity Gregor, you say yes. You have a problem with it. Tell me why.
Just it's now changing the terms of the agreement.
Okay, it's now true. Now, so let me ask you, Trinity. Let me give you a scenario. So, I'm ex-military. Our son is serving down at Fort Bragg. He's a ranger down there, and so we know a lot of folks who suffer from PTSD. And so, what if it was someone who was suffering from PTSD and needed that dog? Would that change your opinion of what would be allowed under that contract, Trinity? What do you think?
I mean, I would definitely feel bad that they have PTSD, but it wouldn't change my opinion of it. I would just, whatever the letter of the law is, that's what I would go by.
Okay, well, we're gonna get to the letter of the law in a sec, but I mean, you'd feel bad for him, right, Trinity? You'd be like, oh man, that sucks. You got that, but you know what? Take that dog and leave. Get the heck out of my apartment. Is that how it'd be? Because look, we got a contract. Is that right, Trinity? Stay with me.
Well, I mean, if we have a contract and they're changing it, then I'm assuming there would be a new pet deposit. Like we would have to redo it because they're changing.
Well, so think
The
about
terms
it.
of
Think
the
about it. You
agreement.
got to think today. We're going to think. I'm going to challenge y'all. Think of this. This person becomes sick after you sign it, right? Because what's an assistant animal and a service dog for? It's to help the person out, right? It's not a pet, right? I told you, it's like their right arm. It's no different in fair housing. The assistant animal is just like their right arm, just like the service animal is when it comes to ADA. So Trinity, here's a person, you sign a lease, a week later says, hey, I've been diagnosed with PTSD and I got my dog. Does that change your opinion at all?
Does it change my opinion or does it change what
Yep.
I'm going to do?
Yes.
Because if they, I mean, my opinion doesn't really matter in that case, but if they have a service animal, then we would have to rewrite the agreement.
It's not a service animal. It's not a service
Oh,
animal. It's an
sorry.
assisted animal.
Assistance animal. Yeah.
Right? Because PTSD doesn't fall under the ADA as far as a disability goes. It is an issue that has to be addressed medically, and one of those things is with an assisted animal. So Trinity, tell me again, you're going to have to rewrite a contract, or you can just say no to that person, right? Because they got sick after the contract.
Well, I mean, I personally probably wouldn't say no to them, but
What if the owner says, what if you're a property manager and the owner says, heck with them, right?
Steve, that's exactly why I don't do property management.
Well, work with me, Trinity. Come on. Everyone enjoys you being on screen versus them right now. Okay. So help me out here. So do you change do you have to change the contract? Do you have to even address the contract? Can you just tell them to get out of your office, or do you have to take care of the person?
Well, I think we would need to change the contract to have some sort of pet assistance animal clause in there in case the animal does any damage to the property.
Awesome, Trinity. Thank you for doing this. Thank everyone. Give Trinity a hand. She's on there. Thank you, Trinity. So here's what has to happen. 1, nothing happens to the contract. Nothing happens to the contract. 2, the person is diagnosed. They're sick. You're going to have to take the animal in there, the domesticated animal. You have no choice to it on it. It is part of that person. 3, it's not considered a pet. It's not a pet. You can't charge a pet deposit. Okay. You can't, you're like, well, Steve, that pig is going to tear up my place, right? That's what Chris was saying. Yeah. If the pig tears up the place, then that damage is applied to their deposit, their security deposit. Okay.
Hey, Steve.
Not Teresa. Yes.
Do we legally have the right to ask them for documentation saying that this animal is an assistance animal?
Yes. So you have you can ask for some kind of documentation that says that they're in need of a service animal. Okay. And now it's not a doctor's note. Like, you can't say I need a note from a doctor. I'll give you the deal with the VA, right? So you got your vet who's got PTSD. He might get a letter from a PA from the VA hospital, or he might get it from an administrative person on letterhead from that say he's suffering from PTSD. That's perfectly legit. Okay. You can't say, hey, how long are you going to be dealing with this issue? Right. You can't be doing that. And so, yeah. So did I answer your question, right, Trace?
Yes.
Yeah.
Thank you.
Okay, cool. Thank you. So you got to let them in. The deposit, meaning there's no pet deposit at all. Okay. And so if there's damage done, you're going to take it out of their security deposit, right? So if you got a year lease, you got a 2-month, you can charge a maximum of 2 months.
Hey, Steve.
Security deposit. Hold on. Hold on just a second. I'll get to you. Just like, perfect. Stay with me, Stella. You can charge it up to 2 months. It'll take it out of there. Well, I'm getting ready to go into something else. Go ahead, Stella. Tell me your question.
I was wondering if in the beginning, if the advertisement said service animals only, would that affect anything?
No, you can't like clause your way out or advertise your way out of this, right? Because remember that, good question, Stella, is that remember when it comes to housing, folks, whether our country does it great or not, I mean, we want food, housing, and clothing for people. Okay. So the laws when it comes to property management are always tilted towards the tenant. Okay. Because as a community, as a country, as a state, whatever entity is, we look at that tenant as being housed, right? Being a roof over their head and the owner of that property is running a business. Okay, so they're running a housing business. You don't have to look far and just look at this COVID, where they've given now up to 18 months of forbearance of paying rent. Right? I mean, you own a property and a tenant was given 18 months not to pay. Right? That's siding with the tenant. Now, interestingly enough, last month, the federal court said that was illegal of the government to do that. Okay. So we'll see how that all shakes out now. But if you were owning a property, you didn't get paid for the last, 13, 14 months on it. So you're falling in secondary. So when it comes to someone who's got an illness, like that in need of like an assistant animal, then we're going to side with them. Now, let's give the two examples. If you have an assisted, we got a service dog that also applies to fair housing. So if you have the blind person coming in and wanting to rent, you're going to let that service animal in, right? That's kind of unquestionable. We already know that, right? It applies to both commercial and residential. On the assisted animal, right? If you're in Harris Teeter, let's go back to Harris Teeter, and I love dogs, so don't be calling PETA on me or anything, okay? But when I go into Harris Teeter and I'm standing there next to the vegetable display, right? And you all seen these pocket puppies that come in? Lanisha Hill, Chambers, you ever see these pocket? Just nod. You ever see these pocket puppies, Lanisha? You know what I'm talking about? These little fur balls in people's hands, like coming in with no mask on, sniffing my broccoli, drooling on my carrots that I'm about to buy. Now, does Lanisha, does Harris Teeter have to let that pocket puppy, which might be an emotional support animal, does Harris Teeter have to let that animal in? Yes or no? What do you think, Lanisha? Just thumbs up for yes or thumbs down for no? Thumbs up. They have to, yes. Hank Griffin, you're correct. They don't have to let them in, right? Emotional support animals are only towards fair housing. Okay. ADA rules towards commercial. This is why airlines don't have to let potbelly pigs, on their planes. Okay. Harris Teeter doesn't have to let them in. ADA is specific as far as, how wide the hallways need to be, the bathrooms and everything like this. That's commercial. Residential is different. So now residential says, okay, well, we take not only the service animals, but now these assisted animals. Okay. So we're going to add this other category called assisted animals. Yes, you got to be recommended for it, meaning you got to have some note that Teresa was saying, was asking about. But now they're not considered a pet. You're going to take them as far as there's no pet agreement. What if you have, for instance, an aggressive pet rule or whatever you want to say at your apartment complex, where they say, hey, we don't allow aggressive pets, like Dobermans, Rottweilers, German Shepherds. And now here comes this vet with a German Shepherd, right? Bob Winstead. Good to see you, Bob. Bob, do you think, what do you think? Do you let that in with a if you have a non-aggressive pet policy, do you let in the German Shepherd or do you say no?
So what's the scenario again?
So you got an apartment complex and in comes this vet that says, hey, I want to rent, but I have a German Shepherd as my emotional support animal for my PTSD. Can you say, sorry, but we have an aggressive dog policy, you're not allowed in, or do you have to let him in?
I would say you have to let him in.
Bob, you're absolutely right. Bob's good. Great. Good job, Bob. Yeah, you have to let him in. The aggressive dog policy doesn't apply because that German Shepherd is actually part of the person, right? You can't look at it as a dog. And you're like, well, what if the next door neighbor of the vet is got, a 6-month-old and is worried about the German Shepherd, eating it, right? Well, that person next door is going to have to deal with it themselves. In fact, you can't do, even if that person complains, like saying, well, that German Shepherd nipped at my baby. Well, you can't do anything to that animal or the tenant unless you or a staff member of your property manager actually sees that incident happen. Remember, right? Because obviously neighbors can just, lie. And so they need you to be there to be able to witness something like, oh, of course, if they actually do bite them and stuff like that, that's different, right? But anyway, that's on that. Let me go real quick because I know we got to break them. I want to make sure we've got some questions here that I've got.
Can I ask one question before we move on?
Oh, yeah, sure. Yeah, Paige.
So just to clarify, assistance animal can be interchangeable with emotional support animal, because that's why I said no from the jump, because I know people's emotional support can change. Like, for example, COVID shifted a lot of people's emotional support and caused, people's emotional capability to change. And I'm on the property management, like landlord side, but I also have a disability. So for me, like I've never needed an emotional support animal until this year. And I know like if I was in a complex where they didn't allow it, that would be something that would have to fly. So when you say assistance animal, you mean emotional support as well too, right?
Yes, ma'am. Yes, Paige. Yeah. Yep. An emotion, the legal term is the assisted animal. And there have been some terms like emotional support page and stuff. There are other terms that are kind of floated out that still fall under the category of assisted animals, right? As long as it's a domesticated animal and the person has some need of that, some verification of that need, right? Then that emotional support animal has got to be allowed in on the property management side. So thanks, Paige. Thanks for your question on that. Yeah, Stella, right? Comfort animal, I guess that's another term. Let me see. Fair housing doesn't differentiate between breeds, correct? Is there, let me just see. Mary Ellen, you tell me about, you had a question about HIPAA, Mary Ellen Santos. Good to see you, Mary Ellen. John Lynn also.
Okay, I got it. No, somebody had said, what about HIPAA? And I said, HIPAA does not apply to private citizens.
Yeah, you're correct. Okay. Now I see. Yeah. Right. John Lynn. Okay. Yeah. And HIPAA is right. We'll just leave it at that. HIPAA doesn't apply to the fair housing at all on this at all. Yeah. Yep. Perfect. Thank you, Mary Ellen. Yep. Good. All right. Any other questions before we move on? All right. So here's the thing.
Steve.
Oh yeah. Go ahead. Hey, Garrett.
Hey, what is the governing body that certifies an animal as an assistance animal? I know the emotional support animal used to be kind of an arbitrary, like you could hop online and just pay for a certification. How is that process now?
I don't understand the question. Sorry, Garrett.
So is there an actual governing body that certifies an animal as an assistance animal? Or is that more of an arbitrary term that you can just say your pet is an assistance animal?
Yeah, so the governing body, the governing body over fair housing is going to be HUD, okay? And so they come up with a definition of what an assisted animal is, okay? And it's broad on purpose. So it's a domesticated animal that has been deemed to be needed by the ailing person, right? And then there's some documentation saying that's ailing. So are you looking for what is the list of domesticated animals?
No, more so like who would actually produce that note that says this animal is an assistance animal?
There is no note that says that. There is nothing that says as long as it's domesticated. That's all that means. So like I said, rabbit, snakes, anything that you could have that you would see in a house. Not an exotic animal that you might see illegally in the house, but any normal animal. And that's why I say potbelly pigs, and which is why it was used on the example, is because that is an animal now that has been considered domesticated.
Steve, I have a question.
Yes. Yeah. So
there's a situation that is in existence now. This person that I know lives in a 55 plus community. They got a new tenant. She has two comfort dogs. They're both pit bulls. And so now the whole community is scared to leave home out of their apartments because the comfort animals have been, when she walks her comfort animal, it tries to attack people's animals, and the people are in wheelchairs. They can't get away from the animal. The new resident can't control the pit bull. She has to physically beat the animal in the face and head to stop it, which to me goes against comfort. But
So a couple things. Let me just address Stella real quick. Thank you for that. One is there aren't multiple comfort animals, meaning they might say that they want multiple comfort animals, but you don't have to oblige. You know, I have 27 dogs here that I consider my comfort animals, right? You got an animal that's going to be your comfort animal. Okay, that's number one. Number two is if these animals are, you know, like nipping at people, Stella, and let's just say they get it on video and they show it to the property management. Well, then the property management can react and say that dog can no longer be here because it's not acting as a domesticated animal. It's actually acting aggressively towards someone. And then the property management can take action. Cool. Let me make sure. John said, my HIPAA comment came about asking for paperwork. That's what I thought wasn't legal to do under HIPAA. Well, HIPAA doesn't apply to actually, HIPAA is designed, John, and you can look this up on it, but it's designed mostly for medical carriers and for the dissemination and protection of the personal confidential information of the medical records. For instance, in a business in North Carolina, as a business, I can ask to see your vaccination card, right? I can actually say, I will not let you enter into my office without a vaccination card. Perfectly legal to do in North Carolina. Now that was just banned in Florida and Texas. They actually had to make a law saying you can't ask for those vaccination cards. Okay. So medical information is not necessarily asking for medical information is not illegal per se. It's the dissemination and security of protecting that. Now, with an employer, for instance, an employer would need to, if they want to say, I want to make a copy of your vaccination card. Well, now HIPAA laws apply to the security of that information that the employers now had. Does that make, did I kind of address that, John? John? I don't know where you are, but hopefully I did. Guys, I've ran over 2 minutes. Go ahead. I'll make that up to you next time. I'll see you at 10 o'clock. We'll come back. You got 8 minutes. We're going to start back up. Actually, just go 2 minutes after. 2 minutes after 10, we'll come back and we'll start back up. Thanks, guys. Okay, guys, we're back. So looking forward to getting going here. If you should see up on your screen, I think we've got about 40 of you have already responded. You have a little poll question that we threw out there for you guys to answer regarding a settlement. If you guys have, you can just take about, if we can take 30 seconds and so you guys answer that, I'll show you the results of that poll and answer the question for sure for you all guys on that. So, all right. So guys, the question here is, if the settlement of a residential real estate sales transaction takes place on a Friday, but the closing attorney is unable to record the deed and the deed of trust until Monday, the prorations of the real estate taxes and rents must be revised. So let's see, I see some results coming in real quick, guys. Let's see, it's about 60-40 split. Let me end it. I'll just share these results with you guys on it. So the answer, so 60% said false, and false is the correct answer. False is the correct answer on it. The standard 2T, for instance, says in there that all prorations are as of settlement. Okay, so settlement is the time that they go and sign the paperwork. It's not as of closing. So you do not need to make those adjustments. Okay, so we're getting back to fair housing. So we've already kind of talked about we talked a lot about assisted animals, service animals, and we're going to now jump into with the fair housing regarding protected classes. And so there's a couple ground rules I want to make sure when we're discussing this. The state of North Carolina looks at each one of you as a business owner. Okay, whether you're a sole proprietor, S corp, partnership, whatever, you're considered a business owner. So you fall under the same lines of protected classes on it as any other business, like Harris Teeter or SAS. What we're going to address are definitions of how it applies to the law. We're not talking social constructs. We're not talking what my Facebook friends think these words mean. We're going through and going by the law, and we're going to talk about the history of it and how it's gotten up to where we are and what it means today as far as the law goes and how it applies to your business. Okay. So that's one. Number two is, let's just remember a little bit about the way laws are formed, right? So it's not dictated, right? So it's not like, the president says this. It's actually Congress, right? Congress comes together. There's some jockeying back and forth of the law. And so there are some nuances within each of these laws that I'm also going to point out as well and try and give you some history perspective behind those things that are carved out. Okay. The other thing is that when the federal government makes a law, a state can make it more restrictive on it, not necessarily less restrictive. Okay, so we're going to keep that in mind, and I'll show you how that applies in some of these situations. So the first thing is, let's talk about there are seven federally protected classes, 7 federally protected classes in the United States. So let me go to the screen here, and here are the 7. You probably remember the acronym Fresh Corn from your pre-licensing days, post-licensing even, out there. So you see that. You see the 7 up there, they're highlighted in blue, right? Fresh corn on that. So let's see. I'm going to ask, so let's do this. On your chat, right? The first thing we're going to talk about, the first anti-discrimination, the first protected class that we have is called race, okay? And so race, we need to define what race is as it regards to the law and to fair housing. So on your chat, I want you to type in there, what do you think race means as it applies to your business and the 7 protected classes? All right, Bob Winston out of the gate. What, like, there we go. There we go. Somebody. Everyone's jumping on the ethnicity back thing. Okay, Gene says color. All right. Okay, so let me, I see everyone's kind of getting on ethnicity on there. Let me ask, I just saw one fly by. Richard Murray. Richard Murray, are you there? Can you say hey?
Hey.
Oh, there you are, Richard. Good. So, Richard, why do you say ethnicity?
Because
Hey, let me ask you this, Richard. Can you see my screen?
I gotta find you.
That's okay. Can you see my share screen?
Yeah.
What do you think national origin means?
Do
you think ethnicity falls under national origin?
Yes.
Okay, so we don't happen to be, we're not, these 7 aren't redundant. So if we have something that says national origin, which let's say is ethnicity falls under it, then ethnicity wouldn't fall under race, would it?
That's very true.
Oh, okay. Yeah. Okay. Cool. Let's see. Trina Knight. Trina, you said color. Is that right? Thanks, Richard. You can mute.
Yes.
Okay. So you see the screen up there, Trina? You see color as a separate category?
Yes.
All right. So color probably isn't it either, right?
Guess not.
Nope. Okay. Well, I mean, I just want to make sure because this is look, this is going to be kind of a learning curve that we're doing on this. So perfect. Trina, thanks. So let me ask April. I don't know your last name. I only see April up there. So April, you have looks like a pretty blouse or dress on with a yellow. Can you hit thumbs up, April? You know I'm talking to you? Okay. So go ahead and unmute. Let's talk for a sec. Let's just chat. You ready to chat, April?
Oh, yeah.
Everyone's excited. I'm calling on you to chat too. So April, what do you think race is then? If it's not national origin, not color, if it's not ethnicity, what is it?
I guess how you see the person.
How you see it. Is that right,
Your
April?
opinion of what you see.
How you see it, how you and I see each other. Is that right?
Mm-hmm.
Do you think that's a definable legal term?
I don't.
Okay. So first, all right. So let me ask you, April. Here's the thing. The very first anti-discrimination, stay with me, April. So the very first anti-discrimination law came out in 1866. 1866, it said you cannot discriminate based off of race for any reason whatsoever. And that was a broad category against all spectrums, including business as well as housing. Okay.
Mhm.
All right. And so what happened what was going on in 1866?
A lot.
Okay, all right. Maybe you're not the history major, but let's say 1866. We had just the Civil War, right? Civil War is ended on it in 1866, and then we were trying to protect people when we made that declaration, right? When we made the law that we're going to protect, who were the people we were going to protect by saying you cannot discriminate against race whatsoever?
Non-white. Anyone that's not white. So,
Well, that would be a color blast site, right? So who are we trying to protect? Come on, there's an open discussion, April. 80 of your closest friends are on this call. We're all friends here.
African Americans.
Okay, so now that's an interesting term, because they're not when it's coming to race. There's no term as African American when it's in race, right? Race, what you're talking about is people coming from Africa, the slaves, right? Isn't that what you're talking about?
Yeah.
Okay, so and the slaves were coming from Africa, right? And so the actual racial term and race term on it, and is called Negroid. Okay, that's the term. Okay, that's where they came from. Now, there was also another group of slaves that were working on, and they're more familiar with working on our railroad systems. What group of people were they? What race was that? Do we know? Do you know where they were from?
Japan. I don't know.
Okay, yeah, Asia, right? And that term is Mongoloid on it. Okay. Now, we also have a term called Capoid, which is going to be Indian. There's Australioid, which is going to be folks that are in the Australia, New Zealand, Antarctica area. And then there's Caucasian, that's up in the European area. Okay. There's 5 identified races. 5 identified races. That's it. Those are the 5. And they've come under different names, and they've had subcategories like it with Negroid. There's East Africa, West Africa. So, but that's it. And it's based off of April physical characteristics. Okay. Mm-hmm. And this is important, right? Because it's based off, because if someone's going to say you're discriminating against me based off of race, if someone said to the charge, and let's understand the process too, folks, is that if someone says, and this is very important too, April, is that, and everyone pay attention to this because you're a business owner, this is important when it comes to the law, is that if you're accused of discrimination, you are assumed guilty until proven innocent. Okay? It's a complete opposite of our legal system on it. So what happens is someone makes a claim to the North Carolina Human Relations Commission. Then they might try to make a discrimination to the Real Estate Commission or to the Attorney Generals. None of them are going to deal with it. It's all going to get funneled down to the North Carolina Human Relations Commission. Each state has a similar commission on it. And they're going to investigate it. And let's just say someone says, Steve Henion discriminated me against because of race. It's going to be really hard for someone to say that I was discriminatory because they have high cheekbones. That ain't going to happen. Do you know of any? I mean, seriously, you don't have, no one answers. I mean, how many people are discriminated based off of their physical characteristics? And one of the reasons, April, we were doing this at that time. Well, April, who was making the laws at the time? Who was making the laws in 1866?
I'm so glad you chose me for this.
I know. Everyone loves that I chose you for it outside of you.
I know.
So who was making the laws in America in 1866? Caucasians, right?
Absolutely.
Yeah, absolutely. Now you're on the bandwagon now, right? So absolutely, it was Caucasians that were doing it. Now, the thing is, April, it wasn't Caucasians were excluded, because I heard you said everyone but white people in it. That's not true. It's all races are protected. Mm-hmm. Okay. When we go to color, all colors are protected on it. There wasn't there's no exclusion to it, but they were identifying them based off of physical characteristics. Okay. Now, this is really important when we're talking about this on the race side of it, because obviously we know there's lots of definitions that are out there, social constructs and all this other kind of stuff, which is why I said we're not going to talk about it. It was about race. Now, at that time, there were some caveats that were carved out of it that still apply today, folks. That still apply today. So, for instance, when that law was made, they said there were people who said, lawmakers who said, "Hey, I own a duplex, and I live in this duplex, and if I don't want to rent to a Negroid, I don't want to rent to a Negroid, and I shouldn't be penalized for that." And they said, "Yes, we're going to give you that." Okay. So today in the federal law, when it comes to the discrimination of race, is if you own a house or a duplex, tri or quad, and you live there, you can discriminate based off of race. You can. It's allowed. It's into the law. Okay. Now you can't advertise that. You can't say, no Negroids apply or something like that, or no Caucasians apply. You can't do that, but you can just simply by saying, yeah, I don't want those folks living next door to me. They also, now what's the reasoning behind that? The reasoning, at least at the time, whatever is justifying, saying, hey, even though we want people to live together and get along, we're not going to force people, especially people who own a property, to have them living right next door. If you sell your property, well, then you can't discriminate based off of that because you're not going to be there anymore. This is the theory behind it. Okay. So they also carved out that said, hey, if my immediate family member lives there, I want them to be able to discriminate as well. And the federal law said, okay, that we'll give you that too. Okay. So you're able to discriminate based off of your relative living there. That's still in the books today. It's not, that second one is not in the books of North Carolina. North Carolina took that away in 1986. Y'all hear that, right? That's 120 years later, 1986. North Carolina took away the right to be able to pass it on to my immediate family member. But today, still in North Carolina, you can discriminate based off of race if you live there. Now, the rest of the states, all the other 49 states, I don't know what they've done to limit it, but the federal law still stands in place today. Okay, so now that's important. That's important when we're moving forward and how we're reacting to the law and how you govern yourself in your business. The next thing, let's an easier one to take on. Well, that's the first one, 1866. It wasn't until 100 years later, 1966. 64, 66, and 68, the civil rights laws that were put into place. Okay. So 100 years later, we added 4 more categories. Okay. That's when we added in color. The color is whatever color. Okay. There's no, I saw someone put up there, or April said, like whites. Whites are covered. Whites can be discriminated against, just like anyone else. Okay, that's why I was addressing that, April, with what you had said. And April, you can click off. Thanks, I appreciate it. April, thank you so much for hanging in there. You did a great job on this. So color is any color at all. Let's go to I'll come back to sex. National origin. Let's go to national origin. National origin is based off of where you originated from. Okay. Now, let's see the basis for it. So my dad, let me just talk, my dad's passed away a while ago. My dad was born in 1912. Okay. I grew up outside of New York City in Connecticut. My father, my mother, they all grew up in New York City. Family line in New York City. Okay. So he was born 1912, went through the Depression, right, as a high school senior kind of a thing. When I grew up, he had a name for everybody. That wasn't necessarily derogatory. I'm just telling you the facts. There was a name for everybody. Everyone had a different name associated, a category, a way of it. Now, this is where these laws came in 66. Because this would be, my dad be close to 60 during this time, 55 or whatever. And what they said was, hey, you can't discriminate based off of where you originated from. So I'm sure you've heard your history lessons, the Irish Catholics that were discriminated against, which adds in religion, the Polish, people who were coming in to Ellis Island on the boats, kind of what they were saying. Okay. Now, before you're all like, oh my gosh, your dad is, should be locked up. Keep in mind, I went up to New York City for the funerals last year, and we stayed in New York City. In New York City, we ate in Chinatown, right? We ate in Little Italy. So we ate in there's sections in our communities that are named after national origin places. Okay, right? Just right. Okay, so that's where that is. In '66, we said, well, you know what? We're not going to discriminate based off of where they're from. Now, I know someone threw out a term like African American. African American is not a national origin. African American is an English term, English meaning American term that's used, and now it's worldwide, obviously, but it was a term that's not where someone originated. If you originate, so you couldn't say someone discriminated off of my national origin because I'm African American. No, if you're from Africa, then yes, there would be that would be justification. I mean, I'm not saying you were, but that would be the way national origin. They discriminated me because I was from Mexico. Okay, I'm a Mexican, and they discriminated based off that. Okay, is everyone at least clear on the national origin, just on the not section? Okay, so now let me ask who's up there. Tana Johnson. Can you hear me? I'm sorry, I don't know how to pronounce your name, Tana. Tona, sorry. So let me ask you a question, Tona. If I own a real estate company, can I say I will not serve, can I say I will only serve people who speak English?
No.
Why?
I'm not sure of your correct answer there.
Well, you were quick to say no. Tell me why you said no.
It would be bias.
Okay. But from the law, why could I not discriminate on that? If someone came to me and said I speak, they wrote on a piece of paper, I speak Slovakian. Do I need to help them?
Or have a translator.
So I'm required to go get a translator.
I don't know if technically you're required to.
Well, I know I'm making you think. I know I'm kind of on you, but think it through. Someone says I speak Slovakian. I got to get a translator. How do I help this person?
Somebody else out there help.
Okay, well, Mary Ellen wants to help apparently, because I see she said something against what I think Shallon said. So Mary Ellen Santos, jump in, help out Tona.
It seems to me that language is directly tied to national origin, and whereas you can't discriminate, you certainly could come to an agreement that you might not be the best fit if you can't really communicate with each other.
Well, you're a business owner, so I'll ask you the same thing. So someone comes up to you, Mary Ellen, and no, let me ask you this premise, Mary Ellen. Well, no, I'll get to that in a sec. So Slovakian, they come up to you and they say, I want to do business with you. How do you handle that, Mary Ellen?
Well, presumably, did I understand what they said? I mean,
they hand you a piece of paper that said that's written by someone.
You find other ways to communicate, I guess.
You have to do what?
I said, I guess you find other ways to communicate, or you could refer them to somebody.
No. The question is you. They came to you, right? Now, because could you not be referring someone out because you don't want to handle them because of their?
If they want me to help them, then I would help them as best as I could.
So it's going to be upon you to find a translator and pay for the translator to help them.
No.
You gonna make them?
No, I think there's other ways you can do translations. There's free ways you can do translations. I mean, we just had a client.
You're going to do this. You're going to be like, speak into my phone.
Who's Latin American, and she spoke very little English, and we communicated through WhatsApp because she could translate.
Oh, okay. But now remember, let's hold on for just a sec, Marilyn. Remember, we are required ensuring that whoever we're helping as a client fully understands the ramifications of everything in every document that they're signing, correct?
Yeah, that's true.
Right? So what if WhatsApp didn't translate it correctly. I'm just asking.
Yeah, no.
What if they came back and said, Mary Ellen, I thought I was only paying $15,000 because my WhatsApp said 15 grand, but you're telling me it's 150 grand.
I can't imagine that the fair housing would require of anybody, particularly when they have such legal liability, to have to like hire a translator or do anything like that. So I'm going to say it's not going to be required if there's.
Thank you. You've come around, Mary Ellen. You came around to what Shallon was saying.
Yeah.
And language is not a protected class.
Right.
This is
No, I
important.
didn't
You
think it
have
was a
7
protected
items
class,
that
but
are
I
up there
didn't
that are
know if it
protected.
was because language is unique to national origin. Then I didn't know if there was like some kind of connection.
No, of course. And that's why we're talking it out, Mary Ellen. We have to think these things through. You're perfect. You're perfect. Thank you thank you for doing that on it. Yeah. Give her a hand. Thank you guys. And thanks, Mary Ellen. You can mute up. So language is not a protected class. Guys, we discriminate all the time on who we have as clients. I discriminate on taking a listing. If you don't want to pay 6%, I'm not going to take you as a client. That's discriminating. Pure and simple. I'm not telling you how to discriminate. What I'm doing is telling you these are the only 7 protected classes for you and ones that you can't discriminate against. Okay. So national origin is being where they originated from on it. Then you come to religion. Religion is not your Fab Five. Okay. I'm Catholic. I'm on that. It's not, Catholics, Protestants, Judaism, Muslim, Hindu. It's not that. Okay. It's actually what they feel is their belief on that. Okay. On that. And so I'm going to give you an example within my own company. Within my own company, I don't even know the year, but you could figure it out. It was when Tom Cruise, who's the point person for Scientology, was on Oprah Winfrey and was dancing on a couch and whatever. And so the day after, they were making in our office lobby, there were being jokes made about what Tom Cruise did and stuff, and they were putting in Scientology into it. And actually, the jokes were pretty funny. I mean, I'll be quite honest with you, they're pretty funny jokes. However, if someone was to walk in who practiced Scientology and overhearing these jokes, Lanisha Chambers, what do you think? Do you think they might feel like they would be discriminated against, Lanisha?
I'm sorry, I didn't hear the first part of your question.
So you heard my story about Tom Cruise and Scientology?
Mm-hmm.
Okay. So if they were having that conversation in the lobby of our office and someone walked in who practiced Scientology, might they feel like they would be discriminated against because people were making jokes about Scientology?
They might, yes.
Yes, they might, right? And that's what we're talking about here. As far as business owners, you're talking about risk management. We're talking about, this. I'm going to give you some examples of stuff, and you have to decide on your risk levels of this, right? Because again, stay with me, Lanisha, is that because the level is when someone says, Lanisha Chambers, you discriminate against me, you have to prove you didn't do that, right? And you have to show that it's a very difficult threshold to meet on purpose, okay? So in our case then, Lanisha, what we had to do, and I didn't realize this until we started teaching this, is that what I had to do then was make a policy that, hey, any kinds of conversation regarding these types of topics that we're talking about can't be in public view, right? I can't limit their free speech to go, they can go in their office, talk wherever they want. But if in public view, when people come in to our office, they can't be joking about someone's religion on that. Does that make sense, Lanisha?
Yes.
Okay. So let me stay with me though. So I told you, Scott, can I advertise in my in my church, we have a bulletin that you get each week, and in the back, the bulletin, there's like advertisements. Can I advertise, do you think, in the back of my bulletin that says Raleigh's favorite Catholic realtor?
I don't think that's good. No.
Yeah, because why? Because really I should be Raleigh's favorite realtor, period.
Right. Yeah.
So I could advertise in the back of the bulletin. I just couldn't I shouldn't put in there Raleigh's favorite Catholic
Correct.
Right. On the same lines, are you familiar with the sign of the fish?
Mm-mm.
Sign of
What do
fish. Sign of a fish is a symbol, has meaning of Christianity, right? You'll see like a fish symbol on the back of people's cars and stuff like this, a lot of times you'll see that kind of stuff. So just now that you know that, do you think that, let's just say you had that sign of the fish on the back of your car. If you think, do you think that if you were driving, you pulled up to a showing and your buyer pulls up behind you and sees the sign of the fish, do you think they might interpret that as like, well, she's partial to Christians?
Probably, yes, they could.
It's a reasonable thing, right? I mean,
Yes.
right? Because you're advertising that. And now some of you are out there, I can see you shaking your heads and stuff. This is, and again, stay with me, Lanisha, is that this is stuff you have to consider. Now, I'm just telling me personally, I'm not telling you you should take that off at all. I don't have it on my car, but I'm not telling you what you need to do for your car. I mean, it's no different if someone had a Catholic, had a rosary hanging from the rearview mirror in their car, right? These things can be interpreted. And remember, you got to prove your innocence on this. Let me give you one other example, Anisha. So I said I'm Catholic. My son, youngest son, goes to a Catholic elementary school here in North Raleigh. Now, if you're in Raleigh, there's a road, a north-south quarter called Falls in the Noose Road, and this sits on it. Okay, and it takes up a good bit of space. Okay, like a block of stuff. From the church to the school, all that kind of stuff. You with me, Lanisha? Oh, okay. In MLS, could I put, do you think it's fine to put head north on Falls and Noose, take a left at St. Raphael's Catholic School?
Yes.
You think that's okay? Why do you think that?
It's just the directions. They're landmarks that you're giving someone to follow directions.
Okay, so you're absolutely right. It's a landmark. Most people in North Raleigh probably know where that is, okay? But what kind of a landmark?
It's a church. It's
a religious,
yeah.
It's a religious landmark, right? So again, what if someone said, I think Steve was discriminating because he was leading this into a Catholic neighborhood. The reason why he puts that in his directions is because he's trying to steer Catholics to that, or just opposite. He's letting us know on it is that he's letting us know so non-Catholics wouldn't go there. What do you think?
I'd say they're reading too much into it.
Yes, but remember, Lanisha, no, and that's cool. I get you. I totally get your opinion on that, right? Your thoughts on that. But again, we're talking about risk.
Right.
Now, risk analysis as you as a business owner is that, remember, you're guilty. So if someone says that to you or to me, right, for putting that in my instructions on it, then I got to show I'm not. And the question that the Human Relations Commission is going to say is, hey, Steve, why didn't you just say take a left on Bland Street? Right? I mean, that's going to be, and what I got no response. I can't say it's a landmark. And they're like, yeah, exactly. We know it's a religious landmark. Don't use the religious landmark. This is why the person is complaining about it. Does that make at least kind of, yeah. And again, it's not saying, right. It's never a problem until it's a problem.
Right.
Right. You don't have to worry. So thanks, Lanisha. Thanks for playing along. Thank you very much for doing it. Thanks, Lanisha. So we got religion. So sex is male and female. Now this is important because this is something that happened in March 1st. Okay. In January, the Supreme Court said that sexual orientation and gender identity, which are not one of the 7 protected classes. It's not one of the 7 protected classes in the federal government. It's not one of the 7 protected classes in North Carolina. It is protected classes in like states like California. Okay. California added that to their state's protected list. So they have 9 in California protected classes. However, the Supreme Court came out in January of this year and said sexual orientation and gender identity are protected as far as employment application goes. Okay. As far as your status as an employment, the EEOC and stuff, those are protected. In March 1st, HUD made a determination that said sexual orientation and gender identity fall under sex. Okay. So what they did was, there's no new protected class. They made a rule. And of course, none of this has been challenged. Now, the Supreme Court's been already challenged and was decided law. What I'm talking about right now, it hasn't been challenged in court. I'm on it. But they made a rule which applies to us today, is that prior to March 1st, if you were the only people who had to abide by protecting, couldn't discriminate against sexual orientation or gender identity, were realtors. And that was because of their code of ethics. The Association of Realtors added that into the code of ethics. Well, now HUD took gender identity and sexual orientation and applied it to the sex portion of the protected classes. So now homeowners who used to be able to discriminate, they used to be able to say, I'm not going to sell my house to two gay guys, which before March 1st was perfectly legal, is not today. Is everyone tracking on that? So that was as of March 1st of this year, that got applied to the category of sex, which by definition, though, by the law definition, is just male or female. Okay. So that's why I say it hasn't been tested in court or law or anything. Just, it hasn't. It was just a rule that was made. And that's what we have to adjust ourselves to. That was in, okay. So that would just happen. So those four additional were in 64, 6, 66, 68. Then it was 1986. We added the two others. Okay. We talked about handicap status. The only thing I want to add on the handicap status portion is a term. Oh my gosh. Let me come back to it because I just blanked on the term. Familial status. Let's go to familial status. Oh, I'm sorry. Now I got it. Handicap. The term is called reasonable accommodations. Reasonable accommodations. When we're talking about, if you have an apartment complex, okay, and if you have an, well, let's just, apartment complex, and I'm handicapped and I have a wheelchair and I come to you and I am renting from you and I say, hey, Kurt Rogerson, I'm living in, I'm living in 1B. I love my place and everything like this, but listen, I work second shift and I don't get home till 11 o'clock at night. And by the time I get home, all the parking spaces are taken up and I got to wheel like a half a mile to get to my place. So Kurt, what I'd like you to do, Kurt, is make a parking space, preferably right in front of my unit, handicap, or even better, Kurt, stick my name on it so that I can park there. Kurt, do you think that is considered a reasonable accommodation?
Sorry.
No, you good.
I think a handicap space convenient to the door is reasonable. A reserved space for you is not necessary.
Yeah. So Kurt, perfect. Thank you. I mean, you can, it wouldn't matter, Kurt, if you did put a sign on it or whatever, the gist being the accommodation is reasonable. It's not costing you a whole lot of money. You're not losing a parking space. You're just basically trading a parking space. That would be considered reasonable. Now, let me ask you, let's go on the same lines, Kurt. I come up to you, you have all your handicap units are filled, right? You have an apartment complex and you had, let's say, 5 units that were deemed handicap accessible. All of them are rented out, but I'm handicapped. I come in and I say, hey, Kurt, I love your place. And I know you've got like a couple extra first floor units. I'd like you to convert that to being handicapped. I would like you to, put the rails up. I'd like you to lower the countertops, that kind of stuff. Is that a reasonable accommodation?
I don't think it is, but you may have to check what proportion of your apartments need to be handicapped accessible to be reasonable.
Yeah. Well, we're assuming that they were all, like I said, in my example, they're all booked up. The answer would be, that's not reasonable. So you would not have to convert that unit. Okay. Now you can also ask, you could say, hey, you could do this, Kurt. You could offer and say, I'll do it for $20,000. That's what it's going to cost to convert it. And also you could ask and say, and I need another $20,000 held in deposit in order to convert it back when you're done. And if the person wants to go through with that, then that's all arrangements that you can make too. right? Does that make sense, Kurt? All right,
Yep.
perfect. Thanks, Kurt. All right, familial status. Jack Farrader. Jack, what is familial status?
Relationship between the people in the house.
The relationship, meaning, so can I discriminate in my 1-bedroom apartment that I want to rent, 1-bedroom apartment? Can I say I will not rent to an unmarried male and female?
No, you cannot.
Why not?
It's protected class, right? Married or unmarried or with or without children.
Oh, say that again.
With or without children, or married or not, you can't discriminate against that.
Okay, so let's take the first part. The first part is correct, Jack. The first part is familial status is for people with children under the age of 18, which includes the female with an unborn child. Okay?
Correct.
So it's about kids. So marital status is not a protected class. Okay? So if I don't want to rent to an unmarried couple, perfectly legit to be able to do that. Okay, on the 1-bedroom on it. In fact, Jack, you know, there's still a current law in the books that says it's illegal in North Carolina to rent a 1-bedroom to an unmarried male and female. Did you know that?
I did not.
Yeah, there is. In fact, it was challenged several years ago by a sheriff who was fired because she was living with her boyfriend. And then she went to court, sued them, sued the sheriff's department, and she won in court, in district court, but then it never went further than that. So the state law still states that that's illegal in North Carolina. Just one of those little known facts, Jack. In fact, I don't think I've ever been, I think it's been many years before I haven't said, that's a fact, Jack.
Okay.
Pretty, just little notice for us. So, all right. So familial status. Now, Jack, are there communities that allow you to discriminate based off of kids?
Sure. Senior, is it over 55?
That's right. Right. 60. Okay. So, right. So this goes back to the laws, Jack, right? When they were making these laws, right, they said, hey, we don't want to discriminate. The largest voting population out there at the time was 65 and older. And what'd they say, Jack? They said, hey, that's fine. You all want to protect those children over there, but we don't want any kids in our neighborhoods. And so they carved that out and they said, okay, 65 and older communities, you don't have any kids. Then the second voting block said, hey, what about 55 and older? Well, then there are people like me who's 56 with a 13-year-old. And I was like, hey, time out. I want to be able to be in your neighborhood. I got a kid. And so what they said was, hey, 55 and older communities, you can have up to 20% of your population can be with children. So yeah, so we got two communities, 65 and older and 55 and older, 55 plus, whatever you want to call it, are communities that do allow in the law to discriminate based off of familial status. Does that make Jack good? All good, Jack?
Yep, sounds good.
Perfect. All right, let me go. We got just a few minutes. Let me go to the chat here real quick. Are there any questions before we move on? I say, there's a lot of stuff going on in here too. Mary Ellen, you said you can advertise, but not the way I have a Cardinal Gibbons magnet on my car. What does that mean?
Now you just got me nervous. Having the Cardinal Gibbons magnet on my car.
Yeah, no, I mean, our older kids went to Cardinal Gibbons, and we had, we chose to have a magnet on there as well. Okay. So it is, and we had one about the school that our youngest went on. So it's, it's just something to think about, right?
Yeah, right. No, Hank
says, I have a fish on my back window. It's a speckled trout. I love that. Let me see. Let me see what else we got down here. Anyone else want to shout out?
I do.
Yeah, Rebecca, what you got?
I have a thin blue line plate on the front of my CRV.
I'm sorry, I couldn't hear. What kind of a plate?
I have a thin blue line that we support the police.
Yeah.
On the front of my CRV.
Yeah.
Could that be considered objectionable?
Well, maybe it can be considered objectionable, but it's not breaking, it's not going against police aren't a protected class, right?
Yeah, right. Okay.
Right.
So in other words, I have a right to express my opinion, just like if you want to do the Cardinal Gibbons magnet, etc.
Well, yeah, and here's the and that's why I said in the beginning I was bringing stuff up. It's like we're not talking about social constructs and all these other little things that people might think about or want to apply. We're going to the law and the definitions of that, right?
Okay.
And so there is nothing out there that says you can't be objectionable. Okay. I mean, quite frankly, people might say that about me on a regular basis. Okay. I have no idea about that, but you can be objectionable. Okay. You could be irritating. You can also be discriminating as long as it's not discriminating against those 7 protected classes.
I gotcha.
Does that make sense, Rebecca?
Yes, it does. Thank you.
Perfect. Someone else gave a shout out. Who else? Who else is out there? Who else is out there?
I had a situation where I had a tenant I had multiple applications for a home, one of which I was aware that they were in a wheelchair. And so I presented the information to the owner, obviously left that portion out so they could do it just on nothing that would be discriminatory. However, after we had selected that applicant, because they were the better fit, they came back with the list of reasonable accommodations. And that's when the owners, and some of those, they asked the owner to handle any residual costs if they couldn't get the money from some sort of funding. And that's where my owner started to have a problem. We came to an agreement. However, would my owners have an ability to say, no, we're not going to make any of these changes? It's your responsibility to do that. If you want to, we're fine, but we're not paying for it. Or could we have gotten into hot water had we not come to an agreement?
Okay, yeah, great question, Jillian. And so hang with me as we try and walk through this. Is that remember, the law doesn't take into every circumstance that's possible as far as possible discriminations are possible, right? I mean, it's broad on purpose, right? Which is kind of why I'm talking about it as a risk analysis that you have to make, right? It doesn't say don't have the sign of the fish on the back of your car. It doesn't say don't have the Cardinal Gibbons magnet on the back of your car. So you got to kind of make those determinations, because what you're in my head as a business owner, I want the least amount of friction to running my business. And I don't just mean like not making people mad and stuff. I just mean I don't want to have to spend time or try to justify something, even if I think I'm not discriminatory, right? Right. So let's go to the reasonable accommodations. On the reasonable accommodations, I would say your owner probably has a pretty good, if the person came in handicapped already, that they should, and they got a tour of the place, right? They should have been able to present reasonable accommodations at the time of application. Okay. And now I'm not the lawyer, right? Right. Let me just put all these caveats. Now, the fact that they came with accommodations and they don't get to determine, they, meaning the tenant, doesn't get to determine this is considered a reasonable accommodation. Okay. It eventually gets determined by HUD and the court systems, or North Carolina Human Relations Commission, or HUD, whatever, is going to determine if it ends up being a reasonable accommodation. So what you're hoping for is that when they come up, you have a mutual agreement, which sounds like maybe you guys came through to, okay? And that's the gist, right? So you try to get a reasonable accommodations. If the owner is like, hey, wait a second, you're asking for 180 reasonable accommodations, I'll take 20 of these, and if you want more, you're going to have to pay for it. Well, that's either going to be in a mutual agreement, or eventually they would go and maybe lay claim, and then the owner and it would be battled out in the system. Does that make sense, Jillian?
Right. So if we, for example, if the owner said, no, we're not going to pay for the pavers that need to go in, you can't get the funding for it. Like, it's up to the tenant to decide, I'm going to make it work or not. We're not then effectively denying him without denying him if the owners won't pay for it.
Right. Correct. Right. Okay. Let's just say, number 21 on the item list is something they're like, I'm waiting to get funding to see if the government will pay for the pavers. Yeah, well, that's not my responsibility. I said no to the pavers. I don't think pavers, I'm just making something up. I'm saying the owner says, no, I don't think the pavers are part of a reasonable accommodation. I could care less whether you get funding or not. I'm not paying for it.
Okay.
And you might even be saying, I don't care if you get funding for it either. I'm not putting pavers because that's going to disrupt my business, right? And now you'd have to show, I mean, obviously he'd want to make sure that it would disrupt his business and not actually help it out. But yeah, you don't, the owner doesn't have to wait for someone to have funding, to do any of that kind of stuff. But to your point, Jillian, it is what we want is an agreement between everybody, right? We want to try and work it out. It's time. Take 10 minutes, guys. We'll see you at the next hour. We're halfway there. Thank you guys very much. Hey, all right, we're getting back. Hopefully you guys have see the question up on the board there. I think we've got about half of you guys, a little more than half, filled it out. If you get a chance, just for the next 30 seconds, if you don't mind, go ahead and filling out that question up there. All right, so the question is, let me freeze this here and share the results. Says the question is, if the parties agree that a refrigerator will be included as part of the sale and the buyer discovers during the final walkthrough that the refrigerator stopped, the buyer may refuse to close. And the answer to that is true. Yes, 70% of you guys got that correct. The refrigerator is part of the offer to purchase. Therefore, it says that it needs to be, if it was in working condition at the time of the contract, then it needs to be in working order at the time of closing. I think someone had a question that I was sent, and I don't know exactly who it was, but I'll just address it real quick. I think someone, and I might not get it completely correct. So someone was asking about the references that I was making regarding the term race and the 5 different categories of race. Those are the 5 that were used at the time and what we were being brought up. So when you talk about Negroid, Capoid, Australoid, Mongoloid, and Caucasian, those were the 5 that were being used at the time of that. So there's no like slanted meaning towards that. So whatever the definitions are at the time of the law and would apply as far as definitions of what race is off of physical characteristics. So when someone says, has a question about social construct, if social construct today, social construct means something different than what I just explained, it's not applying to the law. So you can have social constructs that mean different things in the populace, mores and all out there, but it's not applying to the way the law was and the law and how it's applied today from 1866. Let me think. I think there was something else about the term of African American. African American does not apply. This is, I'm reiterating because there was a question about African American and how that applies. I think it was to nationality or maybe color. I don't know. Color is based off of color of skin. African American is not applicable when it comes to discriminating off a national origin. National origin is where I'm just reiterating now, is where you originated from. You, the person, originated from, not your family line originated from. So, anyway, that hopefully that answers that. Is there any other questions regarding those terms before we move on to contracts? If there are, just shout out because I can't see hands and stuff like that. Okay.
I was saying.
Oh, Carolyn. Okay.
Yes. I was saying if you're using the oid on the end of the words as a scientific reference to race, the terminology I've seen is not Caucasian, it's Caucasianoid. And I was saying you should be consistent in that application. If you're going to say Caucasian versus Negroid, then you should be consistent. And I also said that African-American, we're in America. You said you wouldn't use the term African-American because it's not a universally acknowledged race term, but we're in America. And in America, it is one of the 5 or 6 ways that we identify race.
So let me address that, Carolyn. Thank you for bringing that up. There was no slide of Caucasian versus Caucasianoid. In my material that I have, Carolyn, and I appreciate you bringing that up, I don't have Caucasianoid on it. I have the 5 that I identified on it. So in fact, if you actually go over time, Carolyn, over history, there's actually those 5 different categories have actually changed and adapted. They've had different names over the period of time that was on that. And I'm not going to get into an argument about it, but those 5 have been used over it. So that's fine. I mean, I'll take that for granted. Caucasian versus Caucasianoid on it. As far as African-American, it doesn't matter what African-American and in our terms today, what African-American might imply or the social mores of today or the social constructs of it. African-American, when we're talking about national origin and discriminate against national origin, it is based off of where the person originated from.
I was talking about race.
Hold on. African-American is not in the identifiers as far as discrimination against race. Absolutely not. It's off of those 5 categories that I just said. Yep. That's the law. And that's what I'm speaking to. But thank you for sharing with that.
Send me a.
Hey, Carolyn, I can't continue on, and I don't want to have an argument on it, a discussion on that. But you can reference the law from 1866. It was 1866, and it goes and moves forward to today. If you find something that you think that the Real Estate Commission ought to add into the course, I'd be more than happy to share that with them. Perfectly fine on that. All right, we're talking about contracts on it. Let's move into contracts. All right, let's look at our first, getting ready to the first segment here. Listen.
Mark, a buyer's agent, submits an offer on behalf of his clients for $27,000. The listing agent reviews the offer with his seller. The seller marks out $27,000, writes in $37,000, and initials the change and signs all of the papers.
All right, so we got it where we have a change. Someone authorizes and signs it. The question here is, was a contract created? Go ahead and type in yes or no. Yes or no. All right, we're starting to see a lot of folks. All right, you guys getting this 100%. The answer is no. And actually, so I think 1 or 2 flew by saying it was a counteroffer. Absolutely, that's what it is. It's a counteroffer on there. So thank you guys for getting that. Let's listen to the second one coming up here.
May, a buyer's agent with ABC Realty, submits an offer on behalf of her buyer client to Tammy, a seller's agent with XYZ Realty. The offer includes a $1,000 due diligence fee and a $2,000 initial earnest money deposit. Tammy presents the offer to her seller client, and the seller signs the offer as is without making any changes. Tammy calls May to let her know the seller has signed the contract. Tammy reminds May that the DDF and EMD checks must be delivered to Tammy's office by the end of the day.
Okay, so you got the scenario on here. Now the question is going to be, you got two parts to answer in here. A, are the parties under contract? And then B, when was the contract formed, if it was formed? Go ahead and type that. So either if you say yes, then you need to say when it was formed. If you say no, then it's just no. All right, we got Garrett. Folks are out of the box. Guys, you are on target. Yes, you guys are awesome. So yeah, so it was it is a contract and it's at the time of communication on there. Now, a couple of questions. I just want to let me see. Jim Worthy, Jim, or is it Jimmy? I'm sorry, Jimmy Worthy. Jimmy, what are the acceptable forms of communication?
Email, I'd say text, paper, of course.
Yeah. Okay. So yeah, but in this particular case, do you remember how they communicated it?
Well, at the moment, no.
So it was by phone. So I just didn't want to leave out the phone portion of it, right? So when that communication, Jimmy, right, came over by phone, that's when it actually formed the contract, right?
Correct.
Oh, okay. And then the only other one I think that you left out, you said text, you said was fax, right? If
fax, yeah.
I know. Not everybody has I don't even know if anyone does have a fax machine now, but anyway, but yeah. So fax are the acceptable ways of communication on it. So perfect.
Sweet.
Now, guys, thanks, Jimmy. I'm going to throw up another poll here. Tell me what you think of this question here. Go ahead and take that poll right up there for a sec. It's about due diligence. All right, there we go. Let me share this. Okay, so here's the results that we've got on here. So we've got to the question, to help ensure that the due diligence fee is timely paid, as we talked about in this example, it says, it is a smart idea for a listing agent to refuse to deliver the signed contract until the buyer pays the due diligence. Anyone want to volunteer who said true? Anyone? Jillian. Okay, Jillian, you said true. What? Tell us why.
Well, as a caveat, as I don't do sales, I only do property management, but I said true because it's so competitive. Why would you lock a home under market if you don't have funds yet? Somebody could take however long and you're under contract already.
Okay, so let's think this thing through. Even though I get you're in property management on this, and you can always ask a friend in the chat. but when do you have to have due diligence? First of all, do you have to have due diligence to make it a contract?
No.
No. Okay, good. Do you have to have earnest money?
No.
No. Okay. So now you've got due diligence on it, and the question is, to help ensure due diligence is timely paid, it's a smart idea that the listing agent to refuse to deliver the signed contract until the buyer pays the due diligence, right? Okay. Now, is the listing agent a part of this contract?
No.
Is the buyer's agent?
No.
Okay. So when is the contract formed?
When both parties, the owner and the seller and the buyer, sign it.
What's called acceptance and delivery, right? Acceptance and delivery. So that's when a contract forms. Does it form when does the acceptance and delivery say when it's accepted and delivered and due diligence is delivered? It doesn't say that, right?
No. So it would be a signed contract. So it doesn't matter when they deliver it. They don't even have to provide it?
No, that's not the question, right? The question here is what we have in front of us is, can the listing agent refuse to deliver the contract until a due diligence comes in? And the answer is no.
Okay.
The answer is no, because the listing agent has nothing to do with this, right? Remember, both agents are facilitators in a contract. We don't have anything to do with that particular contract. That's important, right? On it. Now, it doesn't mean it's an important distinction that we need to make sure of, because has anyone had an example where they've had this happen to them, where a listing agent said, thanks, Jillian, you can go ahead and mute. Has anyone had an experience where a listing agent said, I refuse to deliver, or, it's not a contract until then? If so, just shout out. Is anyone? No? Okay, great. Great. I guess if that's the case, because it is happening around, especially when we've got due diligence. I don't know where everyone is from. So in my area up here in North Raleigh, we just wrote a due diligence check on a house we went under contract for $20,000. Okay. I haven't written a contract in the last 6 months for less than $5,000. Okay. So mostly it's been about $10,000 or higher on it. We've had folks on here that have had a due diligence check made out for $425,000, the amount of the purchase price, and still had the contract, it still was rejected as one of the offers. Okay. And so it's crazy times in a lot of places in North Carolina, which is why due diligence is a topic that we're talking about and addressing on here. So is due diligence supposed to be offered, or if it's offered, when is it due? Okay. So let me ask, I'm going to ask, when is that due? So, hey, Larry McKinney, good to see you, Larry. Can you hear me out there, Larry? You just happen to come up.
Hey, how you doing, Steve?
Good. So when is due diligence owed?
Just within a reasonable time frame. I don't know if there's a specific on it.
Right. And Mary Ellen put something up there. She says, and she's right. It says it's payable at the effective date, right? So the effective date is going to be the time that it actually gets communicated. Now, Larry, let's just say you get a contract. Well, let's make up a story. I've got I'm the buyer. You're the listing agent. We got $10,000 in due diligence. We write up. I've submitted an offer to you, and your client accepted it on Friday night. Okay. And I said, hey, you're like, hey, when am I going to get that money? And I said, I'm going to bring it to you Saturday morning. Okay. Saturday morning comes and goes, Saturday afternoon. And you're like, hey, where's my money? Where's that due diligence? I'm like, it's coming, Larry. It's coming. Okay. Sunday morning, I see you in church and you go, Steve, where's my money? Where's 10 grand? I go, it's coming, Larry. Are we still under contract? Is anyone in breach or anything like that?
No, I don't believe so.
Okay, cool. So you don't think so. Does anyone believe we're in breach? Shout out if you do. No one wants to raise out a hand. All right, Mary Ellen, you're volunteering for the whole, Rebecca Rice. All right, Rebecca, I haven't talked to you in a while. Oh, actually, let me go to Paige Hardy. I see some of you guys are out there, so you're looking. Paige Hardy, why do you say yes?
So in this instance, you did agree upon due diligence. And so although due diligence isn't required, that's something that's in the contract. And so in the contract, it always says due diligence is due upon execution. Just like with earnest money, you can identify it's due upon execution within 5 days. So if you don't pay your due diligence, the contract isn't technically a contract, although you signed it. I know that you have to go through like some sort, I've never been in this situation, but I do know that you have to go through some sort of legal stuff, in my understanding.
Okay, so Paige, stick with me because you're on track.
Okay.
Kind of what Larry was saying. Now, if due diligence hasn't been delivered, are we in breach yet? And the question is no. Okay. And here's what's really important that you guys need to understand. Even if it could go a week, it could go 2 weeks. It has to take, in order for it to go to breach, the listing agent, this is what's the important part. The listing agent has got to put in writing to the buyer's agent, your due diligence is due within 1 banking day. Are you all with me on that? Now so the listing agent has to take an action in order for it to approach a breach status. Okay. So the listing agent writes that, sends it out. And here's the important part and why I use the example with Larry on the weekend. It's 1 banking day. So if he wrote me on Saturday afternoon or Sunday morning or whatever and said, hey, you have 1 banking day, that's then to the end of the day of Monday to get the money. Is everyone good with that? Paige, that's perfect. Larry, thank you for doing that. It's a contract, but the buyer would be in default. Okay, I already addressed that. So that's when it comes to due. Hold it. Tori says, I thought it was 5 days, just like the earnest money. Nope, it's due at the time. At the time, Tori. So folks saying that it was due at the time of the effective date is correct on it. So perfectly. Okay, so Sheila then says, what if the buyer changes their mind before? Sheila, come on, talk to me. What do you mean by your question?
Okay, so with the market being as it is, with so many offers being written, let's say that my client makes an offer on 2 properties and gets a response from both after, let's say the agent notified at the same time that the seller accepted their offers and he has to reject one of them, are they still in breach?
Hold on. So Sheila, so This isn't one of your clients, right? You're just like using the
No,
example you heard
hypothetically,
from.
because I write several offers for my clients.
No, Sheila, I'm just saying because this is being recorded, this ain't one of your clients, right?
No.
Yeah, right. Okay. All right. So if, let's say an example, right, Sheila, I know you're just talking about some, you've heard it around the office that people are writing up multiple offers, right, at the same time.
Yes.
I kind of hear you, right, because things go so fast today.
Mhm.
However, one of the hazards is if you have 2 offers out and then you get 2 acceptances back, you're buying 2 houses, or at least losing potentially due diligence, right?
Yes.
Okay. Now, just so we're clear, that buyer would be under contract for 2. Okay. So there's no buyer saying, well, I'm canceling, because there's nothing to cancel, because it takes 2 parties to cancel, right? It takes the buyer and the seller to cancel it. Okay.
Mhm.
But now maybe what the question would be then, right, Sheila, is what is the recourse the seller has if the buyer just says, hey, forget you, I don't want to deal with you,
Mhm.
I'm going to go with this other house.
Mhm.
Well, it's clearly stated in the offer to purchase that the seller is due that and can sue and would probably win in this case, the due diligence in court. Now the question, and then of course, is who wants to go to sue? You know, if it's $500 in due diligence, they're not going to sue for it. If it's $50,000 in due diligence, they very well might sue for it. You know.
Mhm.
So anyway, that's kind of, did I answer your question on that?
Yep.
All right. So, but let me ask you a couple other questions there. Sheila, do you take due diligence in, like, if you're the agent and you're the listing agent, do you expect to get the due diligence yourself? Like, do you collect the money and then give it to your buyer or your seller?
It depends on the situation. Sometimes, like I've had a agent say, "Can you pick it up at the mailbox?" You know, whatever, if they couldn't get to it, or different arrangements. It depends.
Now, why do you think, Sheila, agents are getting in the middle of this transaction? Why does the money have to go to why do agents think the money's got to go to them?
I don't know, because to me, as long as they have a receipt, I guess make sure to cover that the money's received, but I don't know if that's necessary.
April Smith, thanks, Sheila. April Smith, you said page 15. What does that mean? Thanks, Sheila.
Mm-hmm.
April Smith, why?
Hi.
Hey.
Just the acknowledgement of funds for a paper trail. That's what
whose paper trail?
What's required by my firm from the contract.
Well, your firm doesn't have anything to do with this contract. What are you talking about? Your requirement.
Page 15 of the offer to purchase has.
Is that part of the contract?
It's page 15 of the contract.
Page 15 is not part of the contract. Page 15 is a page within the offer to purchase, but it's not part of the contract, is it?
No.
Acknowledgements of receipts of money.
That's right, Paige. It's just an acknowledgement of receipt. It's not part of the contract. If that page never got signed, April, are buyers and sellers both under contract?
Yes.
Yeah, so it's not part of the contract, right?
Mm-hmm.
So then, this is the way I want you to think. So then who's making that requirement? You, the firm, right? Your BIC can't make that requirement as part of an offer to purchase contract. Now, here's where I want you to think about some things, right? When it comes to due diligence, there's no reason. Well, that's not true. There are slim reasons why an agent would get in the middle of the due diligence or earnest money. Now, earnest money, if the earnest money is made out to your firm, then yes, you collect it and you deposit, right? You're depositing into your account. Due diligence, there's no reason that you have to get in the middle of that deal. In fact, to Paige and Sheila's comments, in today's environment with things flying off the shelf, it's even less important for the agent to be in the middle of that money, right? Remember, we're a facilitator. You can Venmo money up to, what is it now? $7,000, I think I pulled up, $6,999. You can Venmo, you can PayPal people. Now, you all think I'm crazy on this, right? You can PayPal, wire the money to the person, right? Everybody should be interested in getting the money to the seller as fast as possible. The only ones who wouldn't be interested is the buyer who wants to, like Sheila was talking about, is like, I don't know if I want to send the money right yet. I got another deal I'm waiting on, right? But I mean, that was just an example of Sheila's. But I mean, if you want to get out of the way, there's no reason you have to be there. If it's Venmo, there's a receipt that you can get a copy of, right? If it's PayPal, there's a receipt that you can get a copy of. If there's a wire, there's a receipt you can get a copy of. It should go directly to the seller. Now there's cases, right? I mean, you have a seller's like, hey, I'm going to be on a cruise and I won't have access to any of this. Hey, April, why don't you do you mind holding that check for me until I get back in the country? And that totally makes sense, right? I mean, if there's logistics that make sense for you to do it, I mean, no one's saying you can't do it. The problem comes in today, guys, with complaints 300% up. The problem comes in with, like Sheila said, the seller didn't get the money, right? And a buyer's agent can't refuse. Like you can't say, my client ain't going to PayPal you, right? Now, you could negotiate that up front too, right? That could be part of the negotiation. The seller could easily say, yeah, I'll take your contract as long as you're going to Venmo me the money or whatever. And that would be written. You could put that, you could actually even add that as part of a part of it, that the money will be Venmoed to you or whatever. I'm on it. Does that make sense, April? Just nod. Yeah. Yeah. Okay. All right, cool. So now let me ask, when we're talking about contracts too, Kyle Gramling, you good, Kyle? Awesome, Kyle. Hey, Kyle, so you're a listing agent and you got 4 offers that come in on your property right now, right? It's been on the market for like 6 seconds and you already got 4 offers, right? Can your seller sign all 4 offers?
They can sign whatever they want, but transfer.
Yeah. Does it make it a contract? Does it make it a contract?
Not until you communicate it. Not until.
Exactly. No, that's the point I wanted to make, is that sellers can sign, because accepting an offer doesn't mean it becomes a contract. That's what you were clearly saying, Kyle, right? It's only when it's getting delivered. And sometimes sellers might want to do that because they don't know what's coming next. Does that make sense? And because it's moving so fast, like if you took Sheila's example, buyers are putting multiple offers out there on it. And the seller might be like, well, I'm going to sign these because I like these the way they are. Let's see what else comes in. Then I'll pick and choose, right? Someone might drop off, a new one might come in, and they might just go ahead and sign it. And then you're just waiting, Kyle, until they give you the A-OK to, submit offer 1 as a contract.
Yep.
Okay. Cool. All right, let's go. Thanks, Kyle. Thanks, guys, for everyone that was punched. Any, let me see. Let me just catch up and see if there's any other questions on there. All right, so let's look at the screen here for a sec. I'm going to go past this one. Okay, so contract 1, we got a deliberate agreement. We got a agreement between two parties, right? And you know what? Let me just, in fact, I want to ask Kathy Jennings. Kathy Rosebaugh Jennings. Kathy, are you there?
I am here.
I just, your name popped up and I like it. So I don't want to go back to a contract for a sec. Can a seller, when we're talking about an agreement, you're under contract. Let's just say you're the listing agent. Okay. I'm the buyer's agent, Kathy. And we get to the closing table. And your seller, for some reason, Kathy, doesn't like you and tells the attorney not to pay your commissions. Are you with me?
Yes.
Can the seller do that? And does the attorney have to obey that?
I would say no, because it's in the listing agreement that they have to pay it.
Okay, well, we're at a closing table. What does your listing agreement have to do with the closing?
It's still a contract.
Yep. What's it got to do with the closing?
I don't have a better answer.
No, and this is this is why I'm having you walk this through, okay? On it is that there are, in every real estate transaction that we're working with, there are 2 agreements going down the track at the same time, right? Your agreement, buyer listing agreement, and the offer to purchase. The fact is, though, neither is dependent on the other, right? Like if the offer to purchase goes off the rails, right? Let's just say due during due diligence, the buyer, right, decides I don't want to buy the house, right? Offered purchase goes off the rails. Your listing agreement's still in place, right?
Correct.
Okay. Same thing goes when we get to close. Can a listing agreement go south, but the offer to purchase still continue down the track?
I
And the answer is
guess so.
Of course. Of course.
Yeah.
The offer to purchase is between the buyer and the seller, right?
So then what would you do? Sue the buyer?
Time out. The bigger picture, and we're getting. I know you want to get paid, Kathy. I got it. Everyone wants you to get paid, but the bigger overall point is that the answer to the question is the seller can say refuse to give commissions, and the attorney's got to abide by that lawful order. Now, that doesn't mean you and your firm aren't entitled to it. Just like in Sheila's case, a seller would be entitled to due diligence, even though they walked or did something else, right? They're still entitled. It's just that your firm would then have to sue them or make some other arrangement to come up with that particular commission.
Okay.
Does that make sense?
Yeah, it makes sense.
Right?
I guess.
It's a I want you to think of it, right? I want everyone to think of it as two agreements going down the track. And I gave examples of how each one can fall off, but that doesn't disrupt the other one going down the track. Cool?
Yep.
Cool. All right. Awesome. Thank you very much, Kathy. All right. So we've got down on the screen 2 or more competent parties on this. So I used to, one of the phrases I use when I teach pre-licensing or whatever is, drunks and minors is when I'm talking about this, right? We're talking about competent. It also talks about duress as well. So, duress. My mom's in the hospital, right? Before she passed away, she's in the hospital for a couple of weeks. Might she be under duress if someone wanted to sell her house? And the answer would be yes, right? So it could be yes, you'd be under duress. Now, Jane, super. Jane, good to see you, Jane. On there, I got you because you ended up flashing. Apparently, you had a nice smile that came across as it was coming across my scene. I was like, I gotta get Jane. She's laughing at something. I don't know if it's me or someone else.
It's you.
So, Jane, I have a 13-year-old son. You have a listing for a $500,000 house. My 13-year-old son, let's just say, has an inheritance and has plenty of money, has $500,000, can show it to you. Can my 13-year-old son go under contract for your listing with you?
No, sir.
Why?
He's not of legal age.
Legal age being 18.
Yes.
Well, now wait a second. Think about this for a second. He's got $500,000.
And I want it, and I think you should get involved and make this happen.
I will make that happen, right? Right. I will make it happen. However, the 13-year-old can go under contract with you.
Oh, Steve.
And here's the thing. A contract comes into 3 different forms. It's either valid, right? Which just means like our normal contracts, right? Valid. Void means that it was void from the beginning. Like, hey, Jane, I want to buy your house for my, I'm getting ready. I need a new location for my crack supply that I got to make, right? Okay. Well, that's void from the beginning because it's for legal purposes, right? So you got valid and void. The middle term in there is voidable. Okay. Which means the 13-year-old can go into, now, of course, it's a material fact, right? Material fact. He's 13. So I let you know, got a 13-year-old going to pay cash, close in 2 weeks on your house. Okay. Goes under contract. Voidable means one of the parties can void the contract out at their discretion. One can void it out at their discretion at any period of time. So the seller would then be acknowledging that the buyer, the 13-year-old, can back out all the way up until closing. Okay. But if the 13-year-old lays over $500,000 and the 13-year-old then gets the deed of the property, you just sold a house.
Sure. Okay.
Right now, and stay with me on it. Now there's another thing. When we sell that house, right? Let's just say that happened with that 13-year-old, with my 13-year-old, right? Your client gave the deed over to a 13-year-old. It's got the deed of the house. Do we have to record that?
Of course you do. After closing?
Yeah.
Yes.
Why?
We just completed a sale. Why would we not record it? Of course it has to be recorded.
Well, that's not my question.
Okay.
Is why do you say it needs to be recorded? I got my 13-year-old's got a deed. Does he own the house?
Yes.
So then what? So do we have to record it? He owns the house. He's got a deed.
Yes, we do. I'm saying yes, and you're indicating the answer is no, but I'm still saying yes.
I know you're fighting me, Jane. I know you're fighting.
My nature.
I don't want to fight with you, Jane.
Okay.
But you just said the 13-year-old's got the deed, so he owns the house, right?
Right.
So there isn't a need to record it to show ownership of a house. He's got the deed, right?
Isn't that what recording it does? Make it public record?
Okay. Well, it makes it public record for a reason, right? This is where I'm walking you down this path, right? So let's just say you sold it to my house, to my son, right? And let's say Jimmy Worthy has a client and also wants to buy, and you sell it to Jimmy Worthy's client too.
Okay.
Okay. Who owns? He's got a copy of a deed for his client. My client's got a copy of a deed. Who owns the house?
Oh, Steve, you pick on this question. Me for this question? Yeah.
Everyone's happy you got this question, but you, Jane.
They are. I'm sure they are. Okay. So to my mind, your child, I don't know what his name is, but let's say his name is Charlie. Charlie owns the friggin' house after we close.
Okay. So the reason why we record is because we're what's called a pure race state when it comes to real estate. And that means that it's the first person to the courthouse to record it who shows ownership to the house. There is no legal requirement that it be recorded. Okay. The reason to record, right, is in order to have standing in the courts if something was to go wrong with the owner of the property. Okay.
All right.
So if you were to sell it for $500,000 to my son and sell it also to Jimmy and my son would have to be, whoever was the first one to record would then be the owner of the house.
Wow.
Okay. And so that is under what's called the statute of frauds. Okay. The statute of frauds, right? I'm trying to walk you through the whole process. The statute of frauds is what says it needs to be recorded in order for either person to have standing. Like if there was a problem with the property or, if they wanted to, to show that I owned it or my son owns it other than Jimmy. That's also the reason, right, why the attorney waits to the very last second or whatever minute to record. Okay. It's because the attorney has to get in all the funds, gets all the paperwork, right? They'll even send the paperwork to the lender from the buyer to make sure they sign off on it, right? He gets all that. And the very last thing he does is then make sure that Jimmy didn't come in and record ahead of my son. Because if Jimmy did sign in ahead of it, then my son wouldn't be able to own it. And then he would not release the funds to the seller. Does that make sense? Ish. Fair. That's also under, he's guided by law called the Good Funds Settlement Procedures Act. That says the attorney cannot release funds until after it's been recorded. Okay. And that's the reason why, like, we can't get our commissions. The seller can't get their funds until after it's been recorded, because the law says we got to make sure the attorney knows that it's actually in the name of the buyer. Is it fair enough on that?
Yes.
Ish.
No, completely.
Yeah. Cool. Awesome. Thanks, Jane. Thank you. The other person I said was drunks on it with minors on it. Now, drunks, I don't mean you're actually falling down drunk on things like this. on it. But I'll give you an example. Some folks, Shallon Lenfest, is Shallon, you on there? Can you hear me, Shallon?
You thought of me when the word drunks came up?
Well, it happens that I did actually. That's funny. So Shallon, you know that there's a good chance that by 7 o'clock tonight, I'll probably have a martini in me already, right?
Wow, hopefully, yes.
Hopefully.
Yeah.
Hopefully I'll have a martini in me. Okay. So I've got a martini in me. Now, let's just say I'm a buyer and I'm your buyer. I'm your seller. I'm your seller. Okay. And we just got we got an offer on the house. That's exactly the way we wanted it, right? And you call me up.
Yeah.
Yep, you call me up and it's 8 o'clock. So, I've already got a martini in me and now I'm at a restaurant and I say, hey, I'm at a restaurant, Shallon. And you're like, hey, Steve, we got great news. We've got everything is the way we wanted it. Just wanted to go over it with you and get you to sign. I just need you to sign it. And I said, well, you know what, Shallon? I think that's awesome. That's awesome. I'm excited. I'm out celebrating. I think I'm going to we're going to open up another bottle of wine and celebrate. When we get home, I'll call you and we'll sign the docs.
Okay.
Now, I'm not necessarily drunk, right? But what have I indicated to you?
That you have been drinking. And so your decision-making could be a little compromised. But hopefully you have a good tolerance and we can make this thing work.
Well, so you're absolutely right. I've indicated to you, Shallon, that that I've consumed alcoholic beverages, right? And that my decision-making process might not be at 100%, right?
Right.
No different than if I had drugs. Right. I have, some kind of, I don't mean illegal drugs, but some other kind of medication that I might have taken, or something like this. But I've indicated that to you. And so to avoid a voidable situation, because if you got me to sign that night,
right,
and I signed it, and then the next day I go, holy cow, Shallon, they wanted $2,000 in closing costs. I didn't see that. And you're like, well, I told you, and be like, well, Shallon, I was a little under the,
You shouldn't be such a lightweight, Steve.
Yeah. So it becomes what at that point? What kind of a contract?
It is, well, if I communicate it to the other side, it's voidable.
It's voidable. That's exactly right, Shallon. It's voidable. Doesn't mean I'm going to void it, but it's voidable. Yeah. So to avoid that voidable situation, you're going to want to just say, you know what? Hey, enjoy yourself, Steve. We'll circle back tomorrow morning.
Right. Let's revisit this in the morning.
Shallon. Thanks.
Thank
you. All right. So perfect. We got that. Supported by legal consideration. Every sale is a cash sale. Okay. That's what it says. Every sale is a cash sale on it. So now, and we already talked about it doesn't need due diligence or earnest money on it. Let me ask someone else. Let's see, who do we got? Sandra Masters. Sandra, hey. Hey, Sandra. It's good. It's good to see. So every sale is a cash sale. So have you seen, Sandra, out there where people will put out on MLS, home sold as is? Have you heard that, Sandra? Go ahead and unmute yourself. Are you familiar with that? People say as is?
Yes, I've heard it and I've seen it.
Okay. So is that if you see something that says as is,
right?
Is that a neutral term, a negative term, or a positive term of that house?
I would think a negative.
Okay. All right. I would tend to agree with you. Probably most people.
Right. I'd be a little concerned.
Okay. You'd be concerned before what? Like repair? Tell me, why would you be concerned?
Right. I mean, I don't even know if that's legal. I'm not sure. I just saw one the other day and I thought about that, but I didn't have time to look into it. I'm not sure.
So you got good instincts, Sandra. It's because if you're going to put as is,
right,
you got to get the permission of the seller to have it advertised as is, because we've already said every house is sold as is. Every house is sold as is.
Right.
Right. Sure. So in our industry, then, if you're going to market it as is, right, Sandra, it would be universally agreed as an industry standard that as is would be a negative of it. Okay.
Right.
Meaning, if you're going to insert that, it's saying something like, well, we're not doing any repairs, or, it needs repairs or something, right? Right. So it would make it look, so you have to have the permission of the seller to do that in the first place. But then again, Sandra, what would be the purpose from the listing agent standpoint to do that? Why would we want to do that?
I don't know. I saw one, like I said, the other day, and I was going to look it up to see exactly what it was, but I got really busy and couldn't do it. I'm not selling real estate right now, but I'm trying to keep my license. But I like to be knowledgeable on everything out there, but I really don't know the purpose for that.
Well, and so I would argue that it needs to be considered very carefully before someone puts as is for a property.
Right.
Because what you're doing is you're now you are now shouting out, right? Our job as agents is what, Sandra, is our job to get the house to closing?
Yes.
No, our job is to get it under
Okay.
contract, right? When you find a ready,
contract,
willing, and
right.
able buyer,
Right.
right? You get paid, you earn your commissions at a ready, willing, and able buyer.
Right.
Fair, right? So
Fair.
obviously we get paid and we're going to closing, but actually you
Right.
earned your commissions without it ever going to closing. And you could sue and win for commissions if that ever came to case. But let's just say, let's go for argument's sake. We're trying to get the most people into the house. Obviously, if you put as is, you're going to limit the amount of people going in.
Absolutely.
Right. Well, then if that's the case,
right,
you got to show cause why you want to do that. Because if a complaint is raised that says, hey, Sandra, she put as is in there, and instead of getting 400 showings, I only got 6.
Wow.
You know, right?
Right.
Right. Because your job is to get people in the door.
Right.
Now, of course, if the seller says, you know, I don't want everybody in my door, I only want to get it to people that, I don't know, whatever reason they want to have, or then that's what you would do. Right.
Right.
And the reason I say this is because some arguments, someone will say, well, Steve, you know what? It just makes it simpler on the process, makes people who are going to offer it give the right amount. It means people know in advance, we're not dealing with everybody. And the seller has already said they're not going to make any repairs. And I'm going to say that even though a seller might say that, you get the right offer, they're going to make repairs.
Right.
I mean, I'm in a negotiation right now where we ended up paying $30,000 above ask price, and we're going in with some key. What I mean key is material fact items. I mean, if it goes back on the market, they're going to have to identify these particular items, right?
Right.
So they're going in and they're going to do these repairs.
Yes.
Now you could say, well, that's because it's $30,000 over. Yeah, you could say that. The argument being though is that sellers will do whatever they need to do in order to get what they want to get, right?
Right.
Okay.
Right.
Paige, I agree. It says I don't think it's always a negative, and I hear that argument about it, Paige, and just all I'm saying is putting it out there is that make sure you know what when you're putting it out what the reasoning is you're putting
what it's for. Okay.
Right. Just make sure you. Thanks, Sandra. Let me see. What was the last thing? Whoops. Hold it. Okay, that's all right. I already talked about that with a crack house kind of a thing. Consideration, and we're getting ready to take a break. Lawful objective, assent, parties competent. I think we already did that. Hold on, I just want to make sure I get through these slides real quick. Stay with me. Okay, you know what? Take a break. We're on our last hour, y'all. Take a break. We'll see you at the top at 12 o'clock. 1 hour left. Thank you. Okay, guys, last hour. We're excited. Woo! You excited? Am I more excited than you are? I don't know. So we'll see. So awesome. So I do want to one thing, and if there's any other questions on here, I saw beforehand. I'll address them. You do have a poll question that's up there for you to answer, but I did want to point out about multiple offers, and that multiple offers are not a material fact. Okay. So if, so even though you might ask a question, the buyer's agent might say, are there offers in, right? Are there, do you have multiple offers? You know, are we in a multiple offer situation? The listing agent is A, not obligated to answer that question. And B, if they answer that question, they have to have the seller's permission to answer that question. Okay. Of course, when we talk about permissions and stuff, obviously you want to try to get stuff in writing that they're going to do that. But in this market, that the way we are right now, that's something you probably want to get addressed before it ever goes live on the market, right? Is, hey, if we get in a multiple offer situation, how do you want me to handle this on it? So let me just make sure Kaja, Ms. Patel, what if an offer is submitted and not being capable accepted by the seller? Would that be considered as an offer submitted? What do you mean by that, Kaja?
Hi, so, when, like you're the listing agent, you get an offer submitted, which is a lowball offer, which is not being accepted by the sellers. Would that be considered an offer submitted, even that was not a good offer, that wasn't accepted? So that was my question.
Yes, any offer submitted is an offer, right? And so even if it's what you would consider a lowball offer, it's still an offer that's being submitted. And actually, maybe to your point too, it's also one that you have to keep a copy of. I don't know what was that crawling. Oh, there it is. It's a bird crawling over here. I was like, duck, Kaja, there's something crawling on your back, but it's apparently your pet. So anyway, yeah. So any offer, and you're required to keep a copy of that with your listing, even if it's rejected on it too, on it too. So now we got a poll question. Let me end the polling here, and I'll share the results with you on there. So the question is, if a listing agent gets basically a verbal offer, question is, should the listing agent present that? And guys, 70% of you got that correct. Yes, you are required to submit that information to the seller. Now, it's a verbal offer, which means nothing more than it's verbal, meaning your contract needs to be in writing in order to be one that is what's called effective and one that can have standing. What we talked about, where you can have recourse on it. That's also along the statute of frauds. But yes, you need to pass it on. And here's the reason. The main reason is any of that information might be valuable to the owner of the property. Give you an example. You're here, you're doing this class, you get a text saying, I want to go see this house. And you've got one of two options. You either quit and lose your license on July 1st and not having your CE, or you finish this off and you do your class and you go do your showing afterwards. You go do a showing, and while you're getting the showing, you get a notification from the listing agent that says, all offers in by 5 p.m. tonight. And your client goes and sees the property. You finish it at 4, viewing the property, and you call up the listing agent and you say, hey, my client likes and wants to make an offer. Here are the conditions that my buyer wants. I'm telling you now because I'm not going to be able to get it in. Physically can't get you that offer until after 5 o'clock. And so that might be the best offer that seller's ever going to see on this particular house. And the seller might say, well, shoot, we'll wait till 6 o'clock till they submit the offer in writing. There's nothing in stone. They can't take other offers on it. So that's one of the reasons why you're going to supply everything you can as soon as you can too. Okay. Let me see. Any other questions would be, okay. I think I got all of those before we move on to, okay. So now we're talking, are there any other questions on contracts? No. Okay. Seeing none, we'll move into cyber security. So let's listen to a video here.
Christy, a broker with ABC Realty, is updating documentation and transaction file while at a local coffee shop. Christy uses the public Wi-Fi and sends her client a reminder via email to sign the engagement letter for the closing attorney's office. Due to Christy working with this attorney previously, she also attaches a copy of the firm's wiring instructions to the email to her client.
All right. So the question is, what did Christy do wrong in that? Go ahead and hit the chat, light the chat up with that. Wow, you guys are on the, Stella says everything. Yes, look at that. You guys are awesome. Awesome. Great job, guys. Thank you very much for all the input. Yeah, fantastic, guys. Yeah, so, okay, first thing is using the public Wi-Fi on it. The commission has talked to you guys about that before, about using public Wi-Fi when you're talking about personal confidential information on stuff, which includes the offer, which includes the attorney's information sheet. Let me remind you, last year, there was a case, a real case in North Carolina, where a buyer's agent did exactly what we just saw. And the buyer transmitted wiring instructions per the notice or whatever, and somehow whatever gets hacked, the money gets taken. And out of I think out of $185,000, the buyer's agent's firm was responsible for $165,000 of that loss. And so, in fact, that case that I taught last year is the reason why in our firm, our agents are not to be forwarding or even being involved in the attorney information sheet, meaning our agents, now this is not the real estate commission saying, I'm just giving you what our company policy was. Because of that, was our brokers are not, can tell the attorney, hey, here's our commissions, this is what we're paying for, whatever we're responsible for, whatever information, on the money side, is our responsibility. But our agents are to tell the attorney to correspond directly with our client regarding that information. Okay. And then we tell our client also, in regards to wiring monies and instructions, to speak directly to the attorney, not to be sending it through email. Now, whether you employ that practice or your firm employs, I mean, that's all up to you. It's a safeguard that we have because of that thing that happened last year. And then, of course, because what we're seeing here today on this particular example and what the commission wants us to do. On the same lines of this, over the last year, the commission mentioned about that you guys should have, if you don't have secured and encrypted email capabilities on it, that you should try to employ that as far as your personal, if your company doesn't do it. So let me in a typical transaction, what will happen is I'll write up an offer in zip forms, and I'll sign it through e-ink, or some of you guys have DocuSign or .loop. Those are usually done through encrypted transmissions of one form. Okay. Now the problem comes in, guys, like if you use DocuSign, for instance, DocuSign, if you have this feature that you're going to use, will then send you a PDF of that signed document to your email. Okay. Well, if that email is your Gmail account or Hotmail account, your free, typical, unsecured method of it, well, then that's a problem. That's what the commission was addressing. Like those would be a problem. We don't want that. You don't want a contract coming into your public kind of Gmail account, your free Gmail. Now, Google and Microsoft, they all have, business accounts, right? That you like our company uses Google products, but they are secured on that platform, right? So I've got a personal Gmail, and then I've got a business Gmail platform. The personal emails are not secured, but the business ones are. And so, they're only talking about the information also that's going to be confidential. Well, we're talking about contracts and all like that. But if you're going to send an email out that says, see you at at the inspection at 2:00, that's not what we're talking about. We're talking about all the other stuff that you would assume would be personal and confidential, like the attorney information sheet and the contracts. They also say that you need to be storing this information also in a secured area. Now, your companies, I imagine the majority of companies have it stored in a secured method, right? So if you're using it on zip forms, DocuSign, but even your CRM platform, that's your company, right? Your company probably says, send us your documents. Okay. They're probably storing it in a secured format online. Cool. If they're even taking a hard copy and sticking it in a file box in their office, cool. But you also need to keep copies of all your transactions, right? So, if whatever, John Lynn is working for Home Coach, remember, if John Lynn's working for Home Coach and then John Lynn decides he wants to go to another firm, then as soon as John Lynn tells me, hey, Steve, I'm leaving, I'm on it, I'm cutting them loose right there. Right, John, John's a nice guy. He comes into my office, sits down. Steve, I want to give you a 2-week notice. Well, first of all, y'all, don't even think there's a 2-week notice, right? Because once John comes into my office and says, hey, I'm going to head out to, ABC Realty, I'm going to delete him from my system. I'm not going to allow him to have access at that point. Pardon me on that. And the reason for that is John just told me he's going to go work for another company. So when he leaves my office, I don't know who he's going to be representing. Every company is going to do this in some manner or not, whether it's instantly or an hour later or whatever. John will not have access to his files within our company. And so John needs to have some storage. If he doesn't have one that is secured, the commission was saying to you guys, you should have a portable hard drive that you store all these documents on. That's actually another thing that our firm has too, is that all of our brokers are supposed to have portable hard drives to hold their files on. So that you have it. Because remember, when John leaves, he's still responsible for all records up to 3 years after they finished, right? So once a closing happens, John's got to keep everything for another 3 years. And so wherever, no matter what firm he goes to. So again, that's another reason for the portable hard drive. Let's listen to one more scenario.
Sandra, a broker with House Realty, uses her smartphone to access transaction files and client information. One day, while Sandra is searching for listings, a text message pops up with a link to set up delivery preferences for a package. Sandra does not remember ordering a package, but she clicks on the link anyway.
All right, so she clicks on a link. We all know it's a problem, right? I mean, I don't know about you guys, but are you not getting text messages left and right from unknown? I mean, it's unbelievable how many texts. So, and people are getting caught up on it too. And there was a lot of COVID related activity, criminal activity type of thing regarding these links too, just to, make you aware of too, if you haven't known about it. Don't click on links off your phone, especially if you don't know about it. Real quick, Renee, you had a question that says paper or electronic records equally acceptable. The answer is yes. Yes, that's correct. And we talked about 3 years. And Dennis, you said how many years? It's 3. And remember, that window starts when you had the last communication on that transaction. So if you have, for instance, a working with real estate agents brochure on customer A, and you're sending them, drip campaigns from the MLS, okay, that's still an active person. So the window doesn't start clicking on that 3 years until that they either close on that house or you cut them loose from that drip campaign. So as long as you keep sending them information, you might have been sending them information for 5 years. That when you need to keep any information with that client from 5 years, and then at least a minimum of another 3. Okay.
I see. Oh, okay. All right. Thank you.
Hey, Ann. Hey. Yeah, sorry. Yep. I didn't know it was exactly you. So yeah. So, perfect. Let's see. Actually, I think there's one more scenario. Let's listen to that.
Joe, a Bick with Farm Realty, answers a call one day. He receives an unfamiliar call from Tom, who claims to be a representative with the firm's cloud storage provider, Documents or Us. Tom informs Joe of a new upgrade, and during the conversation, Joe states the firm is not paying for an additional service. But Tom convinces Joe that the upgrade is needed and it's free. Joe then provides his email address, receives an email with a link, and clicks on it.
All right, just another example of someone clicking on a link and everything like that. And I think who was up there? I think Mary Ellen says, delete it immediately or whatever. So yeah, good job. Let me see if there's anything else on here. Okay, perfect. Good. Awesome. Any questions on that stuff, guys, that we were just talking about?
Lisa, a BIC, opens a trust account for her real estate office at the local bank. Must Lisa take the commission's trust account course? Yes or no? And if so, when must she take the course?
All right, so just on chat, she's going to have open a trust account. Must she take the trust account course? And if so, for how long? Yes or no? Go ahead and type on your chat. All right. So good, guys. Okay. So they do need to get a trust account. But Janie Blanco, how long do you think they've got before they have to take that trust account course?
I'm actually not sure. I'm gonna guess way before they open the account.
Well, and actually, that actually would probably makes the most sense. However, the commission gives them a period of time after deciding they're going to do it before they take the course. And the main reason is, Janie, is that they don't teach the course all the time. So because it's only a commission course. Like we don't teach it, like the schools don't teach it. So only the commission teaches it. So they give 120 days, so 4 months to take the course. I'm on it. It's a 12-hour course, 8 hours online, 4 hours on Zoom as of right now. So they got to do it. Thanks, Janie. Good to see you too.
You too.
So guys, just a couple things. Just there's a new thing coming out that has not been advertised by the commission. And it's a new rule that's going to come out July 1. And I don't know if many of you, and we're still trying to figure out how we're going to deal with it. And there's some questions about the legalities of it from the real estate, as far as whether the real estate commission can do it. But anyway, the gist is of July 1, if any of you have been familiar with what's called table funding. Table funding is a term used for when, and we do this, Remax does it, several other major companies all do this kind of a thing, but it's a version of it. Is basically at a closing, a firm can tell or ask the attorney. They can't tell the attorney to do it. The attorney has to accept it. But say the attorney, hey, we want you to pay our agent their commissions and pay us our fee, 2 separate checks right there at the closing table. So whereas the agent doesn't have to turn it into the firm and then the firm cut a check. Are you all tracking with me on that? So that's been a course of action for forever, is the ability to do that. I'm on it. But really, actually, Keller Williams kind of brought that to our marketplace when they came into the area 20 years ago or whatever. Well, on July 1, the commission's rule is going to be that all money has got to go through the firm. And that includes referral fees. Everything has got to go through the firm and then cut to the individual. Okay. And this is going to be interesting how this happens on this. And so I've been in discussions actually with them, one-on-one discussions, talking to them about this, because like our firm is one who does that kind of funding. And one of the things that is for sure you can do is if you are your own entity, remember, you can set yourself up. Now, provisional brokers can't do this, only full brokers. But full brokers, you can set yourself up as a firm only for compensation purposes. And that remember, there's a caveat in getting a firm license where you don't have to be a BIC, right? So if you go and you set up a company name, right? Jane Doe LLC with the Secretary of State, you can then apply for a firm license with the North Carolina Real Estate Commission for what's called compensation purposes only, and you'll have a firm. So Jane Doe LLC would now be a firm license on it, and then you could receive your compensation at closing. The firm could receive their compensation at closing. Are you guys tracking on that? If you have questions on this stuff, please raise it, because it is one of the things we're going to be talking about on it is it's setting up the entity. You don't have to have a BIC if that's the only, you don't have to be a BIC if that's the only reason you're doing it for compensation purposes. It's a special caveat for firm licenses. Okay.
Hey, Steve,
Stella, yes.
does that mean, that sounds like a good idea to me, but does it mean that I now am responsible for other kinds of fees as, you know, as my own company?
Yes. Okay. So regarding the real estate commission, you would owe an additional $45 each year for your license fee. Okay. So the firm license, right? So a firm license is like an individual license in that, and that's the reason a firm can receive compensation directly, because it has a separate license. Okay.
Yes.
So a firm can receive it, right? Because you have to have a license in order to receive compensation above $50. So the firm license allows that to happen. Okay. So that's why you would pay Stella your Stella's $45, every, June, you'd pay your $45 for Stella, and you'd pay $45 for Stella LLC.
Okay.
That's the only fee you'd have to pay outside of, like the Secretary of State, right? So the Secretary of State has its own LLC fee charges and those kinds of things for setting up a firm and maintaining a firm in the state of North Carolina. There are extra, but of course, the firm doesn't need CE or anything at all on it. Now, on the same measure, when do you need to have a BIC license? Now let's talk about, there are four types of, when we're talking about like, I'm going to get to it in just a sec. Let me finish up. I want to get more into this. Let me just show you a couple other, one more vignette here, and then I'll get to some of the stuff in just a sec.
Chandra, a pre-licensing student, tells her instructor that she had a criminal conviction in her past and asks if it will prevent her from being granted a real estate license. Her instructor tells her she can petition the commission for a decision about the conviction prior to completing the pre-licensing course or prior to taking the license examination.
So the question is Chandra's instructor correct? And yes, Chandra's instructor is correct. Now, pre-licensing, there's a small segment, about 350 people who try to get a license, run into difficulties regarding their criminal background on it, which will require a review. So now folks can get that review in advance of spending the money to taking the test and trying to pass it and do all that. So that is an option that's on there. A little side note, guys, regarding testing. During COVID, post-licensing and pre-licensing testing, classroom testing, went away. Okay. So students could take the pre-licensing class. You can do it online. I mean, we sell the 75-hour class online. You can do it online and go directly into taking the course. Taking the state exam. The old stats used to be, guys, that you had about 50% pass rate of if you had 100 people go in to take the exam, 50 would come out with a license. The new stats are just shy, right around 20% pass rate right now on it, and a lot. They're trying to understand it, because it's now a matter of course action that you can take these online. So they can't put that genie back in the bottle, and so it's like I said, a 20% pass rate now for folks across the board. They have not. I've tried to get data to delineate between those in the classroom, because classroom has been resumed. We'll resume back in the classroom, so you can go back into the classroom on it. So we don't have any data where they haven't been able to go into the classroom. So Anyway, that's just a little bit of information for you on that. So Melanie, tell me your question about, so no more delivering my due diligence or what is that? Melanie?
I just needed some clarification on what you were saying about the due diligence and earnest money. I can no longer deliver it straight, excuse me, to the closing attorney.
No. This, you mean what I was talking about regarding the thing that's coming up on July 1st?
Yeah.
Yeah. Okay. It doesn't have anything to do with due diligence or earnest money. It had to do in the way agents were getting compensated after closing.
Okay.
Yeah.
Okay,
You'll still deliver due diligence or earnest money the same way that you've always done it. Yep.
Okay, thanks.
Yeah, sure. Mary Ellen, how does that work? If you, as a firm, are a member of a larger firm in a listing agreement. Okay. So tell me about that, Mary Ellen.
Well, I was a little confused with the scenario you gave about creating a firm, you as a firm.
Yes.
As opposed to just an individual agent. I mean, either way, if you're a firm, say I created myself as a firm, but I still work for another larger firm.
Right.
Or at least I'm associated with that other firm.
Sure.
And the listing agreement, for example, say we're talking about a listing commission. The listing agreement is with the firm and I'm the agent, the representative agent.
Yep.
So the commission technically is due the firm. So how does me creating a firm give me any advantage to getting paid at the table? I don't see how that.
Okay, so there's a couple things that are in there. Let me try and unpack. And I understand your question, but let me try and unpack it. Thanks, Mary Ellen. Is that okay? First, you're an individual, and you're getting compensated by your firm. Okay, that's scenario one, right? You're just Joe Broker. You're getting compensated from let's just say whatever, Remax. Then now let's just say you're like, well, Steve Henion said I ought to become an LLC. And by the way, caveat, I'm not an accountant or an attorney, so don't take me for any legal or accounting advice. So you say, well, Steve Henion says get an LLC. So you form an LLC and get an LLC license. Now, you do it for compensation purposes only, okay? Eliminates the need for you to be a broker in charge or your firm to have a broker in charge license, okay? All right. If it's only for compensation purposes, and then it would be, so you're not advertising a different name, it's just going to be Mary Ellen Santos Real Estate, right? The same way you were practicing as an individual, then your listing agreements would have Remax on it, okay? Now, now that's advertising, right? That's signing agreements. Okay. We're not advertising Mary Ellen Santos. We're just advertising Remax. Listing agreements are under Remax. However, at the closing table, Remax can get their commission check and Mary Ellen Santos LLC can get their check at the same time. Okay. So Mary Ellen Santos, the agent, doesn't have to wait for it to get to Remax passed down to her. She can actually get it at the LLC, can get it at the time of closing with this new rule. Okay. Now, the new rule is prohibiting Mary Ellen Santos individual from getting it at closing, but the LLC can. Now, on that same guidelines, if Mary Ellen Santos wanted to be advertise herself as like North Carolina's best realtor, okay, now she's not using her name. She's using what's called a DBA, doing business as, okay. Now she'll be required to have a broker in charge for that firm, okay. Once she has that, which is two different names now, right? So now she's doing it. She says, look, I'm not just doing it for compensation purposes. I now want to advertise myself, right? And advertising outside of my personal individual name. So I'm doing a DBA on it. So now she's what did I say? North Carolina's favorite realtor and Remax. Now, both of them have got to be on every agreement. Okay. Now, this is really important when it comes to advertising, because not only are both firms having to be on a listing agreement on it, if you're going to advertise that way, but then on all social media, for instance, that you post. If you do a Facebook post, it's got to be, if you want to open up a Facebook business page of North Carolina's best realtor, that's fine, but it's also got to have RE/MAX on there as well. And tweets have got to have both firm names on it. If you're going to throw it up on Instagram, it's got to have it. Everything has got to be tagged with both firms. It also means that if, let's say let's say a seller wants to get out of their listing agreement, it has to take the approval of both RE/MAX and the Mary Ellen's LLC to sign off on that. Is everyone tracking on that? Let me see if I see we have a bunch of questions on here. Let me see. Let's see. If you set up an LLC as your own firm, do you have to set up an escrow? Okay. So Kimberly asks, do you have to have an escrow? There's no requirement to have an escrow account. So no one has to have an escrow account. That's an interesting question, because the Real Estate Commission has actually tossed around every firm needing one, and that has been shot down so far. So no, you don't have to open that up. Do we incur more liability with compensation only firm? Carolyn Bell, what do you mean by that?
I mean, are there any hidden pitfalls in doing the compensation only firm license? I mean, I know we get the checks cut to us directly, but is there going to be any other things we could be held accountable for?
Well, there are other things. So now the rationale behind also going with that is not only, Carolyn, that's a great question. It's not only for the compensation purposes, because there are tax benefits to having it go through the LLC, right? So like Karen Ann Bell LLC is a firm and a separate entity, and Carolyn Bell LLC would then pay Carolyn Bell, the individual. Okay. And so you can, take out, so taxes would flow through you as an individual, but you can take out the expenses and everything else all at the same time before you pay. Does that make sense? And you might not pay yourself. You might just cut the check at the end to Carolyn Bell with whatever's left over. Okay. As an example. It's also, the theory is that you're also relieving liability from Karen Ann Bell individual. So the LLC might have their own insurance. So when Karen Ann Bell is driving, she might be driving with insurance that's covered under the liability stuff, or the errors and omissions might be. So when someone goes to sue, they would sue Karen Ann Bell LLC, not necessarily Karen Ann Bell. Does that make sense, kind of a thing on that?
Yes.
And then there are some employee taxes and stuff like that you'd have to get into, talk with an accountant and stuff, as you get paid on that kind of stuff. But the theory is, Carolyn, is that it's more beneficial to the individual agent to have that LLC license from liability and tax stand purposes on it, especially if you're doing it from the compensation aspect. So hopefully I got that answered. All right, let me see if there's anything else. Cool. Let's see if, let's go to a couple of these things real quick.
Amin paid his renewal fee this year, but he did not take CE. Amin's parents now want to sell their house. The questions are, can he represent them in this transaction? And would the answer change if Amin takes his CE?
All right, so I'm just going to answer the question on here too, as we're getting through this part here, is that if he doesn't take his CE, he's inactive and therefore can't get paid, can't help anybody out, right? You're either education means you go inactive. If you don't pay, your license goes expired. Now remember this, if you guys are getting this done here. So your license doesn't go inactive until July 1st. Okay. So if you don't do your CE by June 10th, you don't go inactive on June 11th. Okay. You go inactive on July 1 on it. It's just that 2 week 20-day period is called the blackout period, which we can't teach CE during that time. And that's where the schools and the real estate commission are all going back and forth, making sure everyone's got what they're supposed to get and filling in the cracks that might have happened on it. And that's why it's not until July 1 where everyone goes inactive or expired. Okay.
True or false? Pre and post licensing courses may now be taken in an online, self-paced environment.
All right. So that we've already kind of gone over that. Pre and post licensing can now be online on it. One of the things I was hoping to get to that I just don't have the right video up on here is about provisional brokers. So in the example I was giving you guys with Mary Ellen on provisional brokers, that let me ask you this, yes or no? Can provisional brokers be affiliated with more than one firm? Yes or no? Go ahead and type that out. Okay, so we got everybody is saying no. Well, that was true, guys, up until July 1 of last year. So here's what happened. We have been moving towards a team concepts over the last 6-7 years, further and further towards team concept. What do I mean by that? Mary Ellen sets up a team. She sets up LLC. New agents are coming in working under her to kind of give her leads or give them leads and potential clients on this. All right. PBs could not fall under Mary Ellen's LLC as under her guidance. They had to be under the RE/MAX, in my example, guidelines, right? So Mary Ellen could give maybe business, but still were overseen by RE/MAX. Well, these teams were kind of prohibited from giving to the people who probably look for these leads the most, provisional brokers. So the commission made a change and said, well, if you're a full broker, you've always been able to be a member of more than one firm. The reason for that being, let's say you're here in Raleigh, you work for a home coach and you want to do business in the mountains. And so since we're not represented up there, you might ask to be a member of a firm in the mountains because you go up there all the time and do business. Both BICs have to approve it, but you could be a member of two firms. That was full brokers. Another example would be like if you work for a commercial company, then you also want to work for a residential company. Okay. I gave you the example of the provisional brokers. The commission said, all right, listen, here's what we're going to do. We're going to allow provisional brokers to work for more than one firm. So two firms, they can work up to two firms. They can work for Mary Ellen Santos LLC, provided Mary Ellen Santos is in the same building as RE/MAX. Okay. Actually, it's the same address, not even the same building. So if RE/MAX is in 123A Main Street with RE/MAX, cool. PB can work for both firms. But if Mary Ellen moves across the hall to 123B Main Street, the PB can't work for Mary Ellen. The theory being, if the PB is working together with Mary Ellen, they're also being overseen directly by the BIC of the firm RE/MAX. Are you folks tracking? Is there anyone, PB, who has a question on that? So it is a great enhancement for the provisional broker. It does add into the main firm like RE/MAX. They have to oversee everything the same way as if that provisional broker was not with them previously. So they've got to see all the documents. They have to oversee all the actions. Personally, Mary Ellen also has to do that. So if Mary Ellen's the BIC of the firm, she's got to have training and guidance and all that other kind of stuff. She's held at the same standard as the RE/MAX BIC is too. Okay. Questions on that stuff? Everyone so far so good on that? Well, you all have been awesome. We're done. Woo! You made it. Yes, you made it. Yes, the Fitzgerald's all excited. Thank you. So thank you, guys. You're going to get a survey sometime today or tomorrow. Please fill that when you get a chance. You will get your certificate. We will transmit before June 10th. So, but don't call or email us this week. You can call and email. We're just not going to be responding to anything regarding your license and whether it was communicated to the commission. It's going to be. You'll have to wait until the 20th for that. You have all been awesome. We appreciate your business a lot. Thanks, guys, for the conversation. Colleen's going to stay on board to answer any questions you might have. You're awesome. Email me if you got any other questions. Have a great week. You got it done, guys. Thank you.